Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Cannoni, the Justice of the Superior Court, hold an indebtum within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors. I have to ask you those same three questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left here yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about the case since we left yesterday? Everyone said no or should be. Is Dr. Russell in the back there? Mr. Brennan, you can set up if you want to.
Doctor, I'll remind you, you're still under oath. Thank you.
Thank you.
Good morning, Dr. Russell.
Good morning, Your Honor.
May I?
Yes.
Good morning, Doctor.
Good morning, Mr. Brennan.
I had asked you yesterday if your opinions regarding the wounds on Mr. O'Keefe's arm changed between when you testified last year and then the more recent hearings that we've had over the past 4 or 5 months. Do you remember that question?
Yes.
And when I asked you that question, I asked if you had help with your report, and you told us that there was a woman who helped you with your report.
I told you that there was someone who helped me or made suggestions in organizing the report, having certain sentences placed in certain categories.
When I asked you about the identity, the person who actually helped you, I asked you if it was one of the attorneys, and you had said no.
That is correct.
May I approach, Your Honor?
Yes.
May I ask a question?
Yes.
Thank you. You had testified in December 22nd, 2024 in this case?
I believe it was that date, yes.
And when you testified back in December of 2024, do you remember I asked you who it was that had assisted you with your report?
I don't remember that specifically.
Well, I'm going to show you a page from the testimony. This is from the hearing. And I asked you, line 21, page 207, did anybody help you write this report? And what did you say?
I wrote the report.
If you could finish, please.
I had some help with some minor edits, rearranging, some paragraphs or whatsoever, but putting things in the right category.
Then I said, okay. And you answered?
No, I wrote the report.
And then finally I asked, who helped you with your report? What did you tell us?
I said, Mr. Lessie.
And Mr. Alessi, is that gentleman the attorney who asked questions on direct examination?
Yes.
Okay. And so, did Mr. Alessi help you with your report?
What I recall is we discussed the report, But I recall that it was someone else that actually helped me rearrange the report. That's my memory right now.
Is your memory different now than it was last December?
Well, I don't think so, but, you know, you have something in writing.
Do you think you would have testified to that if it was inaccurate?
I don't, Mr. Alessi did not help write the report. He may have helped organize and make a suggestion about what is training versus what is experience, but he did not help me write the report.
Did you have any help trying to describe methodology?
No.
Did you have any help talking about differential diagnosis?
No, I'm very familiar with differential
And
diagnosis.
so, after that report was written, is there any reason why some of your opinions have changed?
I don't believe my opinions have changed.
When you testified at the hearing last year, June 21st, 2024, did you express that you couldn't say with 100% certainty what type of animal, in your opinion, caused those wounds?
100% certainty, that is absolutely correct. And I'd like to see that, but yes, that's my recollection.
If it's your recollection, I'm happy to show you what
Yes,
you
please.
just testified to. You want to
Yes.
see it again?
Yes.
Okay. And by the way, between last night and today, did you get any advice from anybody suggesting you should ask for a transcript when I ask you a question? Did that advice come your way?
That's my general advice from previous times.
Well, did you have any advice last night about that?
Yes.
Who told you last night that you should always ask for a transcript when I'm asking you questions?
Well, I think it was just Mr. Alessi.
So did you and Mr. Alessi, you know there's a sequestration order, don't you?
Yes.
That's a sequestration order that you're not supposed to discuss the case at all with anybody
Well,
during your
we didn't discuss specifics.
Do you know that the sequestration order mandates that you not discuss anything about the case from when you start your testimony until you end your testimony? You know that, right?
I understand that there is a sequestration order.
Do you understand the sequestration order mandates that you're not supposed to speak to people, including the attorneys, about this case overnight? Did you understand that?
There were no specifics discussed.
Or did you understand that you weren't supposed to, is what I'm asking? Did you know that's a violation of the sequestration
No, I
order
did not.
to speak to the attorneys overnight?
I did not know that that particular conversation would be a violation.
So did you meet with Attorney Alessi last night?
No.
How was it that you had a conversation with him?
Actually, it might have been in the vehicle.
You drove together?
Yes.
So did you commute to and from court together with Attorney Alessi?
There's a driver.
Okay, who else is in the car when you left court yesterday?
The driver.
When
Oh,
you-
no, I wasn't with him yesterday, no. Not in the car yesterday, no.
Well, you just said that you spoke to Attorney Alessi yesterday. And I'm trying to figure out, when was it that you were having conversations with Mr. Alessi relative to this sequestration order that you're under?
This morning, riding to court
Okay, so you and Attorney Alessi drove to court?
with the limo driver, yes.
Well, who was in the limo with you and Attorney Alessi on the way to court today?
That was just us.
Just you two?
Yeah.
What else did you both talk about other than that you should ask for a transcript every time I ask you a question?
That's what we talked about specific to this case.
Was it a long conversation?
No, not at all.
The entire ride here, there must be more you spoke about other than just a sequestration order.
We did. We spoke about Boston, how I love Boston area. We spoke about New York. We spoke about other things. And in fact, I have to say that even on the ride back to the hotel yesterday, with others in the car, nobody spoke about the case.
But I'm talking about this morning when you did speak about the case. What else? Not about the Red
That's-
Sox or the weather. What else did you talk to Attorney Alessi about this morning other than you should ask for a transcript every time I ask you a question?
We talked about what I did last night.
about this case?
No,
I'm sorry, but I'm asking you about this case.
that was
I-
it.
I want to know what all the discussions were between you and this attorney today or last night about this case.
Just that I should ask for a transcript.
Well, there must have been some there must have been some context. He didn't just turn to you talking about the weather and say, hey, you should ask for a transcript. You must have been talking about something.
He also generally, not today, but generally says, be honest. Always be honest.
Fantastic. But this morning about your testimony, what did he tell you? Did he tell you this morning you should be honest?
Not this morning.
Okay. Does anybody need to remind you to be honest when you testify?
No.
Okay. What else did he tell? How did it come up? Hey, by the way, ask
I-
for transcripts.
I don't even know how it came up. I didn't put much significance to it.
Well, it was just moments ago it happened because you just got to court. You can't remember the context of the sage advice of Attorney Alessi?
No.
Do you have any memory issues?
No.
May I approach?
Yes.
Transcript. Since you've asked for the transcript, I have it for you. Dr. Russell, this is June 21st, 2024. I had asked you whether you expressed that you couldn't say with 100% certainty. You agreed with my answer, so there's no need to try to refresh your memory, but I'm going to show it to you because you asked. Take a look at line 16. Is that now consistent with the questions I asked you and the answer that you gave, that you were less than 100, you couldn't be 100% certain?
That looks consistent.
Do you want more time with the transcript?
No.
Has anybody else talked to you about your testimony today overnight, Dr. Russell?
No.
When you testified last year, same transcript that we just looked at, do you remember when you gave your opinion to a reasonable degree of medical certainty, you said that you thought the wounds were from an animal, possibly a large dog?
On that same date,
Yes,
may I see the
of
transcript?
course. Pursuant to Attorney Alessi's advice, let me approach.
Objection, Your Honor.
I'm going to strike that, disregard that, Joyce.
May I approach?
Yes. What page you want us to?
23. June 21st, 2024, Doctor?
June 21st.
Page 23, line 14. Will you ask the question based on everything we've discussed today? Is it your opinion based on a reasonable degree of medical certainty these injuries were from an animal attack, possibly a large dog? What did you say?
I said yes.
Thank you. Have that back?
Yes, you may.
Okay, thank you. When you gave your opinion, not this year, last year, you agreed when you were assessing the wound, you used the word, or adopted the word possibly, didn't you?
Explain the context of it?
Sure.
That sentence?
Sure. Go right ahead.
No, you. I'm sorry.
Okay.
I'm sorry. Please
When
rephrase
you-
the question.
When you were asked about your opinion last year, not this year, last year, about whether to a reasonable degree of medical certainty the injuries were from an animal attack, possibly a large dog, you agreed with that characterization. A large animal, possibly a dog, didn't you?
Yes, an animal, possibly a large dog, last year, yes.
When you were on direct examination, there were tons of questions about this word methodology. Do you remember all those questions you were asked?
In June?
Yesterday.
Yesterday, okay, yes.
Yes. And when you were asked about methodology, was that an attempt to try to explain that you weren't just looking at an abrasion and guessing or eyeballing it? You were trying to suggest some type of scientific or medical process to give some type of certainty to your opinion?
That is the process I used.
When you talked about methodology yesterday, you talked about your experience in methodology with knife wounds and gunshot wounds, correct?
Yes?
But there was no methodology whatsoever regarding looking at a photograph and then identifying whether that is consistent with dog bites, is there?
I disagree.
When you described methodology, you were asked by Attorney Alessi whether or not you've engaged in that methodology regarding dog bites. Did you agree that there is really no methodology regarding dog bites?
I disagree.
When you use the word methodology regarding dog bites, there isn't something specific you're looking at as if you were looking at a fingerprint. There are points of comparison. You don't do that, do you?
There are no specific points that are published by a organization, for instance, on how to determine something is a dog bite. However, I did use different methodologies, including what we talked about, the differential diagnosis, the pattern recognition. Pattern recognition, again, is so important in medicine. It's what pathologists use to diagnose tumors.
There
For
is no
instance.
standard. There is no recognized standard anywhere for methodology on how to identify a dog bite wound, is there?
There is no published standard from an organization that I am aware of.
So there is no source, there is no recognized community, there's no certification, there is no recognized method in identifying a superficial abrasion as a dog bite. Isn't that fair to say?
As in many conditions in the medical field, there are no certifications.
How about published standards? Is there any published standards whatsoever, any, regarding claims that a superficial abrasion is a dog bite? Are there any published standards by any organization?
No, but there would have to be thousands of published standards to identify the causes of the thousands of different types of abrasions. So no, there's no published standards.
No published standards. There is nowhere you can point to where the so-called methodology that you were telling the jury yesterday is a readily accepted standard in the dog bite community. You can't point to anywhere, can you?
There are peer review articles which list recommendations on how to determine something is from some wounds are from a dog. These are peer review articles written by esteemed physicians that have analyzed dog bites and have published these and have published an approach to identifying, particularly a forensic approach to identifying dog bites.
Let me ask you the question again, Dr. Russell. Can you point to one place where there is a readily accepted standard in the dog bite community for identifying dog bites? One article, one journal, one book. Can you point to any?
Well, I'm going to mention the articles I mentioned earlier. The article with the lead author of Dr. Demunick and the article with the lead author of Dr. Pollack. And although they're not standards, they are recommendations.
I'm going to ask you the question one more time before I approach. Can you point to one place, one, where there is a readily accepted standard in the dog bite community for identifying dog bites?
No.
And so with no readily accepted standards in the dog bite community, no defined methodology, when you look at a photo like you do of John O'Keefe's arm, you're just eyeballing it based on your personal experience with dog bites, rather than relying on some type of scientific foundation that has been published and accepted in the community.
Objection, Your Honor.
I'm going to allow that.
Isn't that fair to say, Dr. Russell?
No, absolutely not. There are many, many conditions in medicine where there are no standards developed, and yet doctors make, and nurse practitioners and the like, make diagnoses all the time on these various medical conditions, and more importantly, they treat them because they require treatment. There are not published standards on every single of the 10,000 or more medical conditions that exist, including dog bites.
I'm not talking about a stuffy nose or a broken leg. We're talking about dog bites here. So let's focus on dog bites if you would, if you can indulge me, doctor. Regarding dog bites, since there is no standard practice, there is no accepted methodology, and since there is no accepted and approved guidelines, you are essentially simply looking at a picture, a photograph, and just using your past experience with treating dog bites as the basis for your opinion. Isn't that fair to say?
I don't think so. I'm using my past experience, my strong interest in dog bites over 30 years, and the and the articles that I read. The numerous articles I read, but the articles that have recommendations. I'm using all of that combined to come up with a methodology for determining that those are the result of a dog.
Well, you say coming up with a methodology. Are you saying that you're creating your own methodology, that you're the person who has the standard and nobody else? Is that your position, Dr. Russell?
No, the phrasing was not good there. I use standard methodology of pattern recognition and differential diagnosis.
There is no standard in the medical community relative to differential diagnosis and pattern recognition as it relates to dog bites, not other areas of medicine, dog bites. There is no accepted methodology, is there?
That's true.
You mentioned that you have this strong interest in dog bites. Let me borrow a phrase. Do you think you had any confirmation bias when you got into this case?
I don't think so.
Well, you definitely wanted to be in this case. You weren't sought out, you sought the case.
That is incorrect.
And you said you had a strong interest in dogs, and that is one of the reasons you wanted to get involved in this case. Isn't that fair to say?
No, that's actually an unfair statement. I did not want to get involved. I wanted to offer my my knowledge and experience to help clarify issues. I did not want to become an expert witness in this case, and I used, again, as I do on just about every medical condition that I look at and every wound that I look at, I do a differential diagnosis. What else could this be? What else could have caused these scratches and abrasions and wounds? What else before I come to my conclusion?
On your ride over here today, were you instructed that when I ask a question, rather than answer it, give a long explanation about something else?
No.
I would like to put up an exhibit of Mr. O'Keefe's arm, and I want to ask you some questions about it. You and I have had many conversations about Mr. O'Keefe's superficial scratches before, haven't we?
Yes.
And would you agree, looking at these, they are superficial abrasions? Do you agree with that characterization?
Yes.
When we last spoke, just for background, to remind ourselves, we broke these into separate parts so we could discuss them by number, just for the sense of clarity. And we discussed this as wound number 1. Do you remember that?
Grouping number 1, yes.
Number 2?
Yes.
Number 3?
Yes.
4?
Yes.
5?
Which did
I'm
you
sorry,
call
this
4?
one,
4,
5.
5, 6, maybe.
Okay, so as we go through, I'm going to identify them by number. That wasn't done by anybody else. It was just during our discussion so we can have clarity. Is that fair?
Okay.
Sustained.
Is it fair if I refer to this as 1, 2, 3, 4, 5, 6?
I think so.
Okay. When you testified on June 18th of 2024, last year, when you came in, you were asked questions before the actual hearing. You were asked questions about this particular superficial abrasion, weren't you?
I'd have to see the transcript. I believe
course.
so, but I'd have to see the transcript.
Do you remember when you were first giving opinion testimony about this specific abrasion, wound number 1? Do you remember you saying that you thought it was either teeth or nails?
I'd have to see the transcript again.
I will give you the transcript, and as I'm doing that, let me ask you, do you remember your testimony about what you actually said?
So, do you remember your testimony?
For each specific day, no. I remember generally, but not for each specific day.
If you
I've
have
been
an
here many
opinion-
times.
I'm going to bring your transcript up to remind you, but if you have an opinion, it shouldn't change, right? It should always be the same?
Generally, yes.
Okay. So let me ask you before we talk about what you said at the beginning. What is this from? Teeth or nails?
It could be either, but I think that's from teeth.
So when you say they could be either, if you have a methodology and you have a certain standard where you can identify something based on a standard, there wouldn't be so much uncertainty, would there? You'd be able to look at this, consider the methodology, and either come to an opinion whether it was teeth, nails, or something totally different, right?
You know, Mr. Brennan, perhaps I didn't explain earlier, but the nail of a dog tends to be cone-shaped, conical in shape, and very similar to the nails that the canine teeth of dogs. So the shape and the fact that they come to a point makes some wounds indistinguishable.
Are you saying that nails of a dog are so similar to the teeth that you can't tell the difference between them when you're looking at a wound?
I'm saying that they can cause similar-looking abrasions.
Are you able, as the premier expert in the United States on dog bites, able to tell the difference between teeth and claw nails of an animal when you're looking at a wound?
Individually, well, okay, that's a very interesting question. Sometimes it's difficult because they can have similar appearing wounds. So you have to look at the overall pattern in order to make some conclusions.
Well, when you first started testifying in this case, you never suggested you had to look at everything in totality. You were giving opinions regarding individual wounds. Isn't that fair to say?
No,
It wasn't until I began asking you questions and you had inconsistent answers that you've now changed from, rather than identifying individual wounds, now you're saying I can't identify individual wounds, but I can tell you in totality.
I disagree with that. I believe that in the very first time I testified, I mentioned that the overall pattern was important.
When you first testified, so today, before we get to your testimony, you're saying this could be either teeth or nails, but you think it's probably teeth.
Correct.
How probable? Do you think it's certainly teeth, to a reasonable degree of medical certainty? You're not sure? What is the value of your certainty or lack of certainty about what caused this wound?
Reasonable degree of medical certainty.
What is a reasonable degree of medical certainty? That what?
That those are caused by teeth.
Teeth. Okay. When you first testified, your position was it could have been teeth or nails. That is different than saying, to a reasonable degree of medical certainty, teeth, isn't it?
No, there is a small possibility that they could be caused by nails.
When you first testified, you didn't qualify it as a small possibility, did you?
I perhaps wasn't asked.
Well, you answered. Do you remember when you were asked about it and you answered? You talked about that it was a pattern close to the shoulder with parallel marks. Do you remember?
Do I remember what?
Saying that this is a pattern close to the shoulder, right? That they're superficial. You agree with that still?
Yes.
And did you say they were consistent with teeth and nail marks?
Yes.
Okay. Nails on a dog, oftentimes or most times, are horseshoe shaped, aren't they?
They're generally conical shape.
You don't think that nails on a dog in your studies have a horseshoe shape?
I think it depends on the grooming of the dog and if the nails were cut recently. But in general, they come to a point They're at the, you know, they're at the end of the paw. They come to a point, and by the way, the paws can open and close, so the distance between the nails can vary depending on you know, on the how that claw impacts the skin. So in many ways, they resemble the overall shape of canine teeth.
And so to get back to my question here, you're saying that this could have been caused by dog nails?
It's possible.
Do you know, or do you think that the teeth in a dog are different shapes and sizes?
Oh yes, depending on the tooth, there's different shapes and sizes, absolutely.
When you testified the first time and you said that you thought it was teeth or nails, do you remember testifying a couple days later in front of a group of people and you again iterated that this could be teeth or claw marks? That was your testimony last year, teeth or claw marks, right?
Your Honor, I'm going to object to the characterization of that prior proceeding.
So just prior proceeding, folks, that's all that we need.
Did you testify at that prior proceeding last summer that this could have been teeth or claw marks?
I would need to see the transcript.
May I approach?
Yes.
When you first testified on June 18th, Doctor, you were asked questions trying to identify what you thought that wound was. And this is your June 18th, 2024 testimony. On page 37, line 7, the questions begin. And you were asked what you thought they were. You can read any part you want, but line 7 might be a starting point.
Yes, I said that which are consistent with teeth marks. They also could be possibly consistent with nail marks.
Dr. Russell, I'm just going to ask you to keep your voice up, okay?
Okay. Let me see.
Thank you. That was your first testimony last year, yes?
Yes.
Okay. And then did you testify a couple days later and again repeated the same opinion, teeth or nail marks?
May I see it?
I'm asking if you remember.
Yes, I remember testifying.
Do you remember after you worked on your report and submitted your report,
Yes.
after your consultations, do you remember changing that opinion regarding number one? Do you remember changing that opinion?
No.
Do you remember changing from either teeth or possibly claw marks to being very specific, claiming that it was definitely teeth marks?
No.
Are there different types of teeth in a dog?
Yes.
Okay. The pointy teeth, the big ones, those are called canines,
Correct.
and the smaller ones are incisors.
Correct.
There are 6 incisors in a healthy dog on the top and bottom between the canines.
Correct.
Okay. Did you, when you testified subsequently to the original proceedings, did you change your opinion from teeth or claw marks to specifically teeth, and even more specifically canines?
Do you have a transcript?
I do, but I'm going to ask you the question. Do you remember changing your testimony from teeth or nails to being very certain that it was canines, not just teeth, canines that caused that wound?
I became more certain, yes.
You had never said that the canines caused these wounds before you filed the report, ever, did you?
I may not have, that's true.
And so after you did your report, you shifted from teeth and nails to canines. Do you remember that?
I don't think it's a shift.
No one would ever refer to a dog's nails as canines, would they?
No, I don't think so.
That would be inaccurate, wouldn't it?
Yes,
That would be a mistaken use of the word.
I believe so.
When you testified, December 2024, you didn't say nails could have caused this wound. You didn't say generally teeth, you said canines.
I believe that, and that's true. I believe that canine teeth caused that wound.
Did you have any new information about photographs that would help you change your opinion from teeth and nails to canines?
Well, I had been challenged. I had testified several times. I reviewed the case several times and challenged, and each time I reviewed the case, I became more certain that these were from canine teeth. And actually, there's other marks there, but these are from teeth.
You say more certain. You had never said canines before, ever, until that recent hearing. Isn't that true?
I said teeth.
Canines.
It doesn't matter. I said teeth.
Top-
Canines are some of the teeth.
Upper or lower canines?
Upper.
And if it's upper canines, you testified previously that the point of entry would be here at the bottom and the dog would pull this way. That's what you testified to. Yes?
No, I believe you misunderstood then. The point of entry is up there. The first initial point of contact is there. And the dog pulled this way, or Mr. O'Keefe pulled his arm the opposite way.
Dr. Russell, you don't recall that you said that the bigger circles are the point of entry, the dog pulled this way, and then I asked you, how could a dog pull this way when the arc is like this? The dog's mouth would have to be in backwards. Remember that conversation we had?
Objection, Your Honor.
Going to allow.
Do you remember that conversation? You said that the point of entry would be the bigger circle, pull this way, and then I questioned, how could a dog's arc look like this if the teeth went that way?
No, I don't recall that at all.
Remember that conversation
No.
we had? Okay. And so, inevitably, when you look at this part of the wound alone, have you expressed an opinion that you're unable on its own to be able to tell whether this was caused by a dog?
Which part of the wound?
Taking any of these alone, let's start with number one. Haven't you expressed an opinion that taking this alone, you would not be able to say that was from a dog bite?
That is correct. In and of themselves, they're not that specific or characteristic. However, as a group, they are highly characteristic of a dog
So if
injury.
Mr. O'Keefe's arm only had this wound and nothing else, by virtue of what you're telling us, you would not be able to offer an opinion that this was consistent with a dog bite.
That very first wound
Yes.
up there, closest, I agree, yes.
In fact, you've testified about this very issue before. If this was the only wound on Mr. O'Keefe, number two, you would not be able to say that the injury is consistent with a dog bite.
Correct.
I'm going to go through all of these just so we're clear. Same thing with number three. You've provided opinions on this before. If you look at this wound alone, in isolation, you would not be able to say that it came from a dog bite.
Correct.
Four, pardon me, yep, four, same. Looking at the wound alone, you would not be able to say it came from a dog bite.
Correct.
Same for five and same for six.
Correct.
Now, when you testified before your recent testimony, you never had that qualification. When you came into court, you were saying that when you looked at these wounds individually, you were saying that you could identify it as a dog bite.
I disagree with that characterization.
Number two, what caused this wound, Dr. Russell?
Number two, I believe that was dog bite or scratch, but mostly I believe dog bite. And because there's a punctate, little tiny, pinpoint almost, lesion there and there, which could represent bottom teeth.
Okay, so you're using words like could, and we're talking about a reasonable degree of medical certainty. So when you look at this wound here, you said that you are sure or not sure what caused this wound.
I'm saying that individually, that wound, that's correct. I'm not sure individually what that wound was caused by. However, again, as I mentioned earlier, the overall pattern of wounds is what I am convinced of.
I want to go through each of these wounds separately so we understand what you actually recognize with your methodology and what you don't. So looking at wound number two, based on whatever methodology you've been using, are there any signs, indicators, objective criteria you can look at and tell us this is or is not a dog bite based on this methodology you have?
There are some characteristics that are suggestive of a dog bite or dog claw, including the fact that there are parallel lesions, and many of these, overall, by the way, parallel lesions are in the same general direction. So there are parallel lesions, and here they're associated with some punctate or point-like other abrasions right here. So they're consistent with being inflicted by a dog.
I appreciate you using some medical terms to describe this, but my question is more pointed. Is there anything about your methodology, something that stands out about these wounds, that you can say to a reasonable degree of medical certainty that these are consistent with a dog either biting or scratching?
These wounds all by themselves, not to a medical degree of certainty, no.
You said on this first wound, you thought this was from the canines. Those are the big upper teeth is what you're claiming, right?
Yes.
And you're saying today anyways, starts here at the bottom and goes up. Is that
No.
your position today?
That's not what I said. I said the
Okay.
exact opposite.
So it starts here and comes down.
Correct.
Okay. And these two scratches, they're linear, just like these are linear, aren't they?
Yes.
But you have a problem with these because if these are the canines, you see the spacing there?
Uh-huh.
This is nowhere close, is it?
I didn't say that these were caused by canines. And spacing also, there's reasons why the spacing could be different.
Well, we can talk about that in a second. Are you suggesting that these exact, well, not exact, these two linear abrasions, just like 1 and 2, are you suggesting the canines caused these?
I don't know what caused those, which teeth caused those, or which nails caused those.
When you testified last year on June 18th, you said that this was either teeth or claws. Can you give us any development of your opinions, whether or not you think that is teeth or claws?
Excuse me? No, well, I couldn't hear because of the fan.
When you testified on June 18th, you said wound number 2, the top 2 linear abrasions, you believe were either teeth or claws. You've shared with us now you have improved your study and have new opinions. Do you have a clearer opinion whether this is teeth or claws?
Objection, Your Honor.
Sustained, ask it differently, Mr.
Do you have an opinion whether this is teeth or claws or not something totally different than a dog?
I believe they are teeth or claws caused.
When you testified at trial and in that hearing that they were teeth or claws, you changed that opinion as well at the most recent hearings, didn't you?
Your Honor, I'm going to object to the word that was used and has been done before.
Mr. Brennan, word it differently.
Sorry?
Word it differently.
Okay. Did you testify at a more recent hearing that teeth made these, not teeth or claws, but teeth?
I may have, and I would like to see that.
May I
Can
approach?
you just hold 1 second? Could you please turn the fan off, Paul? Joyce, is it okay if we turn the fan off so we can hear better? Thank you. Thank you very much, Officer DeLong.
May I approach?
Yes.
From your December hearing, page 100, line 5, when you were asked about that second wound in December, and I asked whether you changed your opinion from teeth or claws to just teeth, weren't you asked specifically about that on page 100, line 5?
Yes. But may I read it?
Sure, I'll read it with you.
Okay. I said, I'm not sure on the second set. So this is the set just above the elbow.
I'm not sure exactly what teeth made these. They could, one of them could, one set of these could be canine, one part of this, and then adjacent in scissor tooth. But I'm not sure on the second set, so this is the set just above the elbow.
Yeah, I think the first part of that paragraph is talking about the first set
Yes.
up there close to the shoulder, and then the sentence, but I'm not sure on the second set, so this is the set that's just above the elbow. I said I'm not sure.
And then, sorry.
Oh, go ahead.
Are you done?
Oh. Oh, yeah, actually, I did make another comment. What is it? So, however, what is interesting and certain is that there's an upper set and a lower set. So, this mark was an upper tooth. This is a lower tooth. What I was referring to is this mark here and that mark, and then this mark here and this mark here. So it appears that this is from upper, and these are from lower. That's what I was referring to.
And so when you first described this wound as teeth or claws, at the most recent hearing, you had a certain opinion that this was teeth, didn't you?
Yes, I was leaning towards teeth. Correct.
Well, it didn't seem like you were leaning. You said these were from the upper teeth.
Yes.
You said it matter-of-factly, not with any qualification. Your claim at the last hearing is this was from teeth.
That's what I believed.
And today, you're saying you don't know if these were teeth or claws.
Not with 100% certainty.
You didn't qualify 100% certainty. You were asked your opinion, Dr. Russell. You
Yes.
were asked, what do you think? And you didn't say, well, not 100% certainty. Your claim, the first time you testified, teeth or claws. Recently, you said teeth, and now you're saying you're not sure.
No, I'm saying I believe that those marks are from teeth, but I'm not 100% certain.
Suffice to say, looking at wound 2 alone, you cannot say this was caused by a dog.
In and of itself, no.
What tooth do you think caused this wound?
I don't know.
Do you think this in any way could be caused by dog teeth if you're claiming that this is dog teeth?
Excuse me?
Do you think there's any way these two could be caused by dog teeth if you're saying that these two were caused by dog teeth?
Yes, it could be, but I don't know which teeth. And I don't know the extent of the bite, how much impact there was, and how much pressure, how much contact there was between the teeth and the skin.
The canines are the longer teeth in a dog's mouth, aren't they?
They are.
And when a dog bites, it's very common for the canines to puncture, isn't
It's
it?
It's common if there's enough force, and it's common that you might have two canines if the strike is perpendicular to the skin. But if you have a tangential strike, a partial strike where only part of the teeth impact, you'll get different configurations.
Look at the spacing, Dr. Russell.
Did you say strike or strike?
Strike with a K.
Look at the spacing, Dr. Russell. A dog causing these wounds, the canines are not going to have such a dramatic distance between them because dog canines don't move, do they?
They don't, and I'm not claiming that these two parallel stripes in this case, or abrasions here, I'm not claiming that those two were caused by canines.
You think a dog is going to leave a wound with linear abrasions using its incisors as opposed to its canines? Is that your opinion?
It's possible if that's the only part of the mouth or the jaw that actually touched the skin, if it didn't go back as far as the canines.
Did you ever look at the underside of Mr. O'Keefe's arm?
I did.
Posterior side?
Excuse me, pictures, yes.
Yeah. And when you looked at the photographs of the posterior side of Mr. O'Keefe's arm, did you find anything conspicuously absent from underneath his arm?
Well, first of all, let me clarify. Part of this is the posterior aspect of the arm. So are you asking me, did I look at the underside of the arm, the fleshy part
That's
of the
exactly
arm?
what I'm asking. It's a question I've asked before. When you look at the other side of Mr. O'Keefe's arm, did you notice anything conspicuously absent?
Yes, there's an absence of wounds.
When a dog bites, I don't care if it's a law enforcement dog or a domestic dog, you know it's like a lever, a dog's mouth, isn't it?
It can be if both jaws strike the skin. However, there are many times when only the upper jaw strikes the skin.
The lower jaw is a lever, locks, and that's part of the clamping and pulling process of a dog, whether it's a law enforcement dog or a domestic dog. You know that, don't you?
I know that they are attached.
Your claim is that there's many, many different dog bites on Mr. O'Keefe's arm. Are you suggesting, to a reasonable degree of medical certainty, that these are a number of different dog strikes and coincidentally every single one of them lacks any wound to the underside of his arm?
Yes.
Your claim is that a dog penetrated the sweater on the top, but the lower jaw did not leave any wounds?
I'm claiming that that's not what I'm claiming. No. As I mentioned earlier, these could be from lower jaw. Those right there.
You're saying could be.
Could be.
That's speculation. We're asking you for your medical opinions. Your medical opinions. Do you have any evidence that the dog's lower jaw, you said maybe upper, maybe, that the lower jaw, even just once in this whole event, penetrated Mr. O'Keefe's skin?
No, nothing penetrated the skin. There was no actual penetration of the skin. These are abrasions. But yes, I believe that these small marks right here, punctate marks, may be the result of lower jaw impact.
Rather than deal in speculation and maybes, can you tell us to a reasonable degree of medical certainty whether or not this was caused by a tooth?
Objection, Your Honor.
We're going to strike the first part. Why don't you ask the other part?
Can you tell us to a reasonable degree of medical certainty whether this superficial abrasion, could you put that back up, please, was caused by a dog?
In and of itself, that part only, no.
Can you tell us anywhere on Mr. O'Keefe's arm to a reasonable degree of medical certainty where the lower jaw impacted Mr. O'Keefe to leave even a scratch?
Not with a reasonable degree of medical certainty on individual wounds.
And not just individual wounds, I'm talking specifically the lower jaw. Can you point to one wound, one abrasion on that arm where you can say to a reasonable degree of medical certainty the lower jaw caused any of those abrasions?
I believe there are several areas where there's impact from the lower jaw. However, I cannot say with reasonable degree of medical certainty that part only.
Let's look at number 3 to move along. When you first talked about these wounds, again, is it fair to say that you described that it could have either been teeth or claw?
I'd have to see it.
Okay, I'll bring it to you. You don't remember that testimony?
I remember, again, I've been here many times, so I want to be,
Well, do you have the
Specific.
opinion today, and I'm getting the transcript for you, Dr. Russell.
Thank you.
Do you have the opinion today that that those were either teeth or claws?
yes.
What's your opinion today?
Well, I think that most likely they are from teeth marks.
Well, rather than most likely, we deal with reasonable degree of medical certainty. To a reasonable degree of medical certainty, can you give us an opinion regarding the cause of those marks?
Objection, Your Honor.
So I'll strike the comment.
Can you tell us to a reasonable degree of medical certainty whether these wounds were caused by teeth or claws?
Individually, no.
Did you ever change your mind about the source of these abrasions?
Can you be more specific?
Did you ever claim that any of these abrasions were from upper or lower teeth?
I don't recall changing my mind.
You don't recall if you've ever said that? Let's separate these bottom wounds. Do you have an opinion to a reasonable degree of medical certainty whether these were caused by teeth or claws?
I have an opinion.
To a reasonable degree of medical certainty?
No.
Do you have an opinion to a reasonable degree of medical certainty whether these were caused by either a dog teeth or dog claws?
I have an opinion.
To a reasonable degree of medical certainty?
Individually, no.
The one near the wrist, you had testified yesterday, there's lines in what you believe to be an arc, correct?
Yes, they have a general overall appearance of an arc.
If there's an arc and there's 2 linear abrasions on the outside borders, wouldn't these necessarily have to be the outside borders from canine teeth?
Not necessarily.
They're longer than the middle ones, aren't they?
The abrasions are, but doesn't mean the teeth are.
If this was an arc, like you claimed, you think different teeth other than the canines could have caused the outside scratches?
It's possible.
And you do note the distance between the top and bottom of those wounds compared to the distance in number 2 and the distance in number 1.
I see the difference, yes.
And you have to concede, Dr. Russell, that the same set of teeth, the same canines, could not reasonably have caused this wound, and this wound, given the distance between the inside and outside.
First of all, I'm not certain that these are all canines, as I mentioned earlier. Secondly, you have to take into account that skin is elastic. It bends. It depresses. So you could have 2 prongs, for instance, of a pitchfork, for instance, just as an example, impact the skin in different places, and the measurement between the 2 can be slightly different depending on the elasticity of the skin and the underlying structures.
This is not a slight difference, Dr. Russell, is it? The distances-
Again,
Objection, Your Honor.
So there was a question at that, so I'm gonna let that in.
Again, Dr. Russell, the distance here, it's not insignificant, is it?
Mr. Brennan, I already mentioned that I did not think that these were caused by two canine teeth.
And these, the distance between these two, have you measured them?
I approximated them, yes.
What did you- what did you come up with?
Visually, and I can see that there's a difference.
What was your measurement for this one?
I think about 4 centimeters, and this was a little bit more.
Did you note that in the report? Did you
No, I
actually
did not.
measure them, did you actually take out a ruler, measure them, and document them as you studied these wounds? Did you go through that process during your methodology?
No, because this is an image, and there's no scale in this image as to how far away different points are. So my own measurement would not be accurate because there's no scale in the picture.
Why did you go through the process of measuring them if you're now saying that it's inaccurate after I asked you if you memorialized it? Why would you even do it if you're now saying it was inaccurate?
It was an approximate measurement in my mind.
In your mind?
Yeah.
Okay, but you never put it on a piece of paper, report, notes?
That's correct.
Why would you even go through the process if you're looking at it and your explanation is, it's only a photo, I wouldn't be able to tell? Why would you even try to?
I think probably everybody in this room has already done the same thing.
And if anybody in this room did the same thing, it would be quite obvious, doctor, that the gaps between 1, 2, and 5 are dramatically different from each other, aren't they?
They are. However, I'm not saying the same exact teeth caused those marks.
When you testified yesterday, you used the term differential diagnosis. I want to ask you a lot of questions about differential diagnosis. Do you remember using that term?
Yes.
And differential diagnosis was really just a way for you to try to get your opinion to the jury that these injuries were not consistent with a car accident. That's what a fancy way of doing it is, right?
No, it was a method I used.
Differential diagnosis, you're claiming that you can say this is not from a car accident or a car collision. That's what you're trying to say, aren't you?
That was the result of my differential diagnosis and my pattern recognition
So if you're-
methodologies.
If you're going to exclude a cause of the injury, in this case, a collision, you have to know a little bit about collisions, don't you?
Yes, I don't know how to answer that.
Well, try.
Can you be more specific?
If you're going to say that these superficial abrasions could not have been caused by a car collision, you kind of have to understand a little bit about the mechanics of a car collision, don't you?
Actually, I disagree. However, I've treated thousands of victims of motor vehicle accidents and have seen the wound patterns that they come into the emergency room with. And that forms a basis for me.
Do you really think?
I'm sorry, she needs to finish.
Did you finish that answer, Dr.?
No.
Did I cut you off?
I believe so.
Oh, I'm sorry. Please continue.
No, and the thousands of victims of motor vehicle accidents, I've looked at their wounds, I've treated their wounds, cleaned their wounds, touched their wounds, and that is what I use as a basis, part of my basis to determine that these were not caused or not consistent with a motor vehicle accident.
When you first gave that opinion that it wasn't consistent with the motor vehicle accident, it's fair to say you didn't have a lot of information at that time when you first came in and said that, correct?
Specific to this case,
Yes. Yes.
I didn't have a lot of information, that's correct.
Okay. And so in order to rule out a collision causing these wounds, let me ask you, are you an accident reconstruction expert?
Reconstruction, no.
Did you ever go to any academy for training to receive any type of degree or certificates in car collisions?
Actually, I did receive a certificate in hit and run accident investigation from the Massachusetts Criminal Justice Training Council when I was a police officer.
Do you agree that what training you did have was rudimentary?
It probably was, yes.
Well, not probably. You've used that word before. Wouldn't you say that any training you have had has been rudimentary?
In terms of
Accident-
accident
Yes.
investigation, yes.
Have you ever testified as an expert anywhere in accident reconstruction.
No.
Do you know what ACTAR is?
Actar?
Yes.
No.
It's a certification group for collision specialists, accident reconstructionists. Is it fair to say that you're not ACTAR qualified?
Objection, Your Honor.
I'm going to sustain the objection.
Are you ACTAR qualified?
No, and I don't know any physicians that are.
Have you ever gone to a scene of a car collision and done an investigation and written a report and reached a conclusion about the cause of the car collision and the injuries that were related to that car collision?
No, that's outside my scope.
It's beyond your expertise.
Beyond the expertise of a physician, yes.
Right. Yet, yesterday, you offered the jury your opinion that these wounds were not consistent with a car collision. Did you offer that opinion yesterday?
Wounds are in my area of expertise. So yes, I am very comfortable talking about wounds from a variety of sources, including motor vehicle accidents.
I'm sorry, I didn't want the siren to interrupt you.
Okay. Yeah, wounds are definitely within my area of expertise.
When you considered your opinion to this jury that this was not caused by a car collision, do you know what type of vehicle is in question?
Yes.
Have you ever studied the vehicle to look at the make, model, the height of different things like the bumper, perhaps the taillight? Have you ever studied that in this case?
I'm aware of some of those factors,
Have you
yes.
studied that before you gave this
Studied.
opinion? Yes. Did you go and actually look at the photos, do any measurements before you came up with this opinion?
Not before I came up with the opinion, no.
Did you ever look at the damage to the rear taillight of the defendant's vehicle and see if it was in similar or the same height of Mr. O'Keefe if he was standing up? Did you ever do that?
I have looked at
And when
photographs.
you looked at the photos, did you see that a 6'1" man like Mr. O'Keefe, if he stood, his elbow would be the exact height of Miss Reed's broken taillight? Did you notice that?
I noticed that there was a similar, that the height would be similar. The height of the elbow and the taillight, yes.
Did you look at photographs of Miss Reed's broken taillight and see if where the break was corresponded closely or directly to the same height as Mr. O'Keefe's elbow and forearm?
I did.
And did you see that it matched up height-wise perfectly?
Close, yes.
You have really no, respectfully, comprehension about the details of the car collision in this case, do you?
I have some understanding of the allegations of a possible collision.
Do you know how slowly or fastly Miss Reed's Lexus was traveling on January 29, 2022 at about 12:32 a.m., right around the time that you think these wounds happened?
I have some knowledge of the alleged speed at the time of the alleged collision.
Do you have any knowledge about the surroundings, the outside, whether the ground was soft or frozen?
I understand that there was snow on the ground.
How much snow do you understand was on the ground when Mr. O'Keefe's body first landed on that ground?
Several inches.
Where did you get the information that there were several inches of snow on the ground when Mr. O'Keefe landed?
You asked me when?
Where did you get that information from?
A report that I read.
Have you ever seen the videos or the reports that when Mr. O'Keefe was moved from the ground, there was grass and dirt under him?
Yes, I saw a picture.
Okay. Not 2 inches of snow. The ground, the cold, hard ground. Did you see anything that said that?
Yes, I saw an area of grass
Have you ever
in the
looked at-
picture.
Have you ever looked at Mr. O'Keefe's pants to see if there was any dirt or grass stains on the back of them?
I've seen pictures.
Did you realize when you were forming your opinions about the source or the genesis or the cause of these abrasions, did you look at his pants and study whether or not he landed on snow or landed on the hard ground?
I did not see any evidence of grouse on the pants.
Did you ever actually look at
I
the
don't, I
pants?
don't know if I looked at the pants,
So
to
when you
tell
say
you
you
the
didn't
truth.
see any evidence, are you saying you didn't look, or you looked and you didn't see anything?
I looked at pictures of the clothing that was available at the hospital.
Did you look at anything about the pants, photographs, the actual pants themselves? Did you look at them?
I looked at the pictures that were available at the hospital of his clothing that was on the floor.
Were part of the photographs that were available for your review and your conclusions of differential diagnosis, was part of that evidence photographs of the back of his pants?
I don't recall.
If you're going to make an opinion about something outside your expertise, that this was not consistent with a collision, wouldn't you want to see as much information as
So
possible?
let's, yes, we'll come to side by Mr. Herman.
Dr. Russell, before you gave your opinion to this jury, suggesting that Mr. O'Keefe's wounds on his arm were not caused by an impact with the motor vehicle, did you go to the scene of 34 Fairview and look around in the corner of the yard?
I did not need to.
Did you?
No.
Did you look at photographs to see if you could identify the land, the dirt, whether it was flat and smooth or whether it was bumpy, whether there was rocks or debris in that area?
Yes.
And you went there and looked at it?
No. You asked me if I looked at photographs.
When you looked at photographs, did they show whether that ground had any bumps or divots or rocks?
It showed that there was a little bit of a hill in that area.
Could you tell from the photos, were they close enough so that you could see what the makeup of the ground was?
No, most of the ground was covered with snow.
Did you know that there were bushes right near the area where Mr. O'Keefe was found? Bushes with branches. Did you know that?
Not very close, no.
Did you see the bushes in the photographs near where Mr. O'Keefe lay?
Right where he laid, no.
How about next to him on the left? Did you see those bushes?
There was some other stuff there in the photograph, but the photographs I looked at were not of excellent quality.
Do you have any understanding or information you can share with us the angle of Mr. O'Keefe's body at the time of any impact with a motor vehicle?
I don't see any medical evidence that there was impact with the vehicle.
Do you know Mr. O'Keefe had other injuries other than just the superficial abrasions on his arm?
Yes, but no significant injuries below the neck.
How about on the head? Was there a significant injury?
Oh, yes.
When you considered excluding car collision as a source of those wounds, did you consider in your history that you've seen, or have you seen, let me strike that, have you seen in your history multiple victims of a car collision where
Many.
they were
Sorry.
hit by the same car?
Probably, but I can't recall a specific case.
Would you agree with me if a car ran into a group of people and caused a number of injuries, those injuries to different people could vary wildly from one to another?
Yes.
Even if the car was going at the same speed and ran into a group of people, those injuries could be totally dissimilar from one another, couldn't they?
Yes.
Some person, unfortunately, could be killed if the car was going fast enough and hit them the right way. Yes?
Yes.
Another person could have a less severe injury, maybe a broken bone.
Yes.
Another person in the same exact collision could have scratches.
Yes.
In fact, there are cases, I'm sure you've studied, where people have been hit by cars, thrown airborne, and had no wounds on them at all. Have you seen that?
Could you repeat that?
Are the instances that you have considered where a person is hit by an automobile, actually thrown, removed from the ground, thrown in the air, and gets up unscathed with no injury at all?
No significant injuries, correct.
So a car collision can cause wildly different injuries depending on many, many unpredictable factors. Isn't that fair to say?
Yes.
When a vehicle's involved, have you ever been involved in treating patients that received injuries from broken plastic or broken glass in a car?
Yes, many times.
And when you've seen them, have those injuries differed on a person as far as cuts and abrasions from glass or broken plastic?
Yes.
When you were considering excluding car impact or collision as a source of Mr. O'Keefe's injuries, did you consider whether or not Mr. O'Keefe could have been struck on the side of the car in a clip-type event rather than being run over?
Yes, I considered multiple scenarios.
Had you, or do you agree that injuries from a side swipe or from a clip could be much, much different than a full rear or front impact being run over?
They could be.
Did you do any study in this case when you were thinking about excluding the car collision or impact as the source of Mr. O'Keefe's abrasions, about what his body posture was, how he may have hit a motor vehicle? Did you consider that?
I considered several scenarios,
And when you con-
several different
Sorry, she needs to answer.
several different positions.
And when you considered that, what did you conclude as far as Mr. O'Keefe's body movement at the time of any potential impact?
Oh, first of all, I didn't see any medical evidence that there was an impact. There were no significant injuries from the neck down, no fractures, no bruise, no internal injuries, no no lacerated organs, no collections of fluid in the lung cavities, the abdominal cavity, no significant injuries from the neck down, and so yes, I used that and tried to put that in a scenario of his various positions. What could he have been? Standing, kneeling, sitting, lying down on the ground. I did all that.
You were a police officer before you went to medical school, weren't you?
Yes.
You had arrived at scenes of many, many car collisions, hadn't you?
Yes.
What is oftentimes left behind after a car collides with an object?
Debris.
Debris field, yes? Did you look at the debris field in this case?
No.
In the cases that you went to wherever you saw car collisions, some of the debris that you would find could be broken glass or broken plastic. Isn't that fair to say?
Yes.
And when you went to those scenes, you would often find broken glass or broken plastic in a debris field near where the victim was found or laying. Isn't that fair to say?
The debris field would be usually near the collision, if there was a collision impact.
And when you were considering excluding car impact or collision in this case, did you take a look at the entire debris field to determine how close or far it was from Mr. O'Keefe's body?
I couldn't tell on
Did you
the
ask any
photographs.
question? I'm sorry, please finish.
I couldn't tell from the photographs.
And before you came to your conclusions, did you ask anybody for any more information so that you could make a fair assessment of that information?
The injuries here were so characteristic that, and they were so parallel to one another that I couldn't even imagine pieces of glass or plastic or even metal lining up to cause those injuries, lining up in a certain fashion to cause those regular striations.
Rather than imagining, did you make any effort to actually seek information so you could identify and evaluate the debris field around Mr. O'Keefe's body that morning?
I did not.
Have you ever, as a police officer, looking into car collisions, ever hear of the term knocked out of one's shoes?
Not as a police officer.
Have you ever heard of that as a medical expert?
I've heard of it as a civilian, yes. Not as a medical expert.
Could I have Exhibit 74B, please? In your study, before you gave an opinion excluding an impact or a collision as the cause of Mr. O'Keefe's abrasions on his arm, were you aware of this photograph where Mr. O'Keefe's sneaker was found on the side of the road?
I am aware that there was one shoe off, correct?
Were you aware that it was wedged right up against the curb? Were you aware of that?
I'm aware, I have been aware of that, yes.
And when you came to your conclusion that you offered that the injuries are not consistent with a impact or car collision, was this photograph part of your consideration?
No.
If we could have Exhibit 99D, please. In your study to give an ultimate opinion, where you suggest that a car collision or impact was not the source of Mr. O'Keefe's arm injuries, were you aware of this photograph of Mr. O'Keefe's hat found at the bottom of the snow in the corner of that yard?
No.
Do you see underneath that hat, there was not 2 inches of snow, it looks like dirt and grass?
Yes.
When you gave the opinion that he was on 2 inches of snow, would it be important to know whether or not he fell directly on the hard ground or on snow?
It could be important, however, it could be. If the ground was frozen, if it wasn't frozen, it could matter a little bit.
Exhibit 73, please. When you were reaching your conclusions, you said you considered some of the debris field. Did you see this photograph of a piece of taillight that matches the defendant's taillight of her SUV? Did you consider this piece of evidence that was found in the debris field?
Not specifically.
76A, please. Same question. Did you consider this piece of the debris field when you were coming to your conclusions that you offered us yesterday?
I considered that there would be several pieces of metal, plastic, or glass at the scene.
Did you consider this picture of plastic from the defendant's rear taillight found at that scene? Did you consider that before you gave your opinion to the jury?
No.
In the foundation of your opinion that a collision or impact did not cause Mr. O'Keefe's wounds on his arm, was it important for you to determine whether or not the taillight to the defendant's Lexus was broken early that morning?
I think there needs to be more to the question.
Okay. When you were considering potential causes of injuries, did you know that the defendant's Lexus rear right taillight was broken in missing pieces?
Yes.
Was it important to time when that taillight was broken?
What do you mean by time?
You understand that Mr. O'Keefe was found on January 29th, 2022, yes?
Yes.
Early morning hours.
Yes.
When you were making your differential diagnosis, was it important for you to learn whether around that time the defendant's taillight was broken?
It was important to know. I still don't understand the question. I'm having a trouble
Okay.
understanding the
It's
question.
my fault. I'll try to ask it a different way. You were considering as much facts and information as you could to give a solid opinion in front of this jury, weren't you?
Yes.
And you ultimately have offered an opinion that the wounds to Mr. O'Keefe's arm are not consistent with an impact or a collision with a vehicle, yes?
That's correct.
You know the vehicle in question in this case is the defendant's vehicle, her Lexus.
Yes.
And you learned that her right rear taillight was broken in missing pieces, yes?
Yes.
Did you want to know if there was any evidence depicting when that taillight was broken, in considering this conclusion?
Yes.
Did you know that there was video from 5:07 a.m. showing that the defendant's taillight was missing pieces?
Objection, Your Honor.
I'm going to allow that.
Not at the time, but I expected that if there were a collision, that there would be pieces of the car, a car, involved. So it didn't really make any difference.
When you were trying to rule out a collision between Mr. O'Keefe and Ms. Reed's vehicle did not cause these injuries, did you want to seek that information about the broken taillight and date and time it?
A broken taillight in and of itself could not cause those injuries. There would have to be multiple projections from the vehicle that were lined up in a certain pattern to give those parallel marks all in the same direction. So, that's why a broken taillight could not have done that.
So you, in your investigation, you did not want to know when that taillight was broken?
Oh, I did, but for information only.
Did you review the ring video from 5:07 a.m. at Meadows Ave?
Later on, later on in the, not initially when I had the initial records, but later on I did.
Did you have that information before or after you arrived at your opinion?
Oh, after.
So you had already arrived at your opinion, then you received new information, which was that ring video, correct?
And it confirms, yeah.
And then you received more information. Did you receive photographs from a dash cam during a wellness check showing the defendant's Lexus missing pieces of her right rear taillight at about 8:03 a.m. that morning?
Would that be, I'm not sure which video that is.
Well, it's not a video. If we could put up Exhibit 10. It actually was from a video. Did you look at this picture during your differential diagnosis?
I think I've seen that picture before.
And
The
could we
car,
have
the vehicle parked, yes.
Exhibit 11, please. Did you consider this picture in your differential diagnosis?
I don't know that I ever saw this picture.
Seeing this picture, do you see that the right rear taillight is missing pieces?
I can't even see that. Oh, yes, I do see that. But again, these pieces would have to be lined up in a certain configuration in order to cause those wounds.
So seeing this photograph now for the first time, it doesn't in any way shape or change your opinion, does it?
No.
You had, as a police officer, when you're excluding the source, and in this case you're saying the cause of Mr. O'Keefe's scratches on his arm could not have been from a collision, do you listen to witness testimony or do you review witness statements?
Objection, Your Honor.
I'm going to allow that. Just, do you do that?
As a police officer, in investigating a car accident, is that what you're asking me?
Yes.
Did I take witness statements?
Yes.
Yes.
And do you value the statements as part of your analysis?
I give varying values depending on what I believe to be the veracity of the witness.
Have you listened to the statements of the defendant herself in this case regarding potential impact?
No, what do you mean?
Well, have you seen any statements made by the defendant to any media about potential impact or collision in this case?
Oh, are you referring to what you've asked me previously about, did I hit him or something of that? What do you mean specifically?
Have you seen any of the media statements by the defendant, 2020, Nightline, docuseries? Have you seen any of these statements in your analysis of whether or not there was a impact, a collision between the defendant and her Lexus and Mr. O'Keefe? Have you seen any of those?
I did see some statements, but that was after I rendered my opinion.
And some of those statements, after you rendered your opinion, did some of those statements come from the defendant herself?
Yes.
And when you listen to those statements, did you hear any of them talk about the idea or issue of collision or impact?
Yes.
And when you listen to those statements after you formed your opinions, did in any way, change the analysis of your opinion?
Absolutely not. And I'll tell you why.
Please do.
Because she had, the defendant had undergone a very stressful event, finding her loved one in the snow. And so after a stressful event, many people suffer from what's called an acute grief reaction. It's very common. And they do things that seem to be irrational. They ramble. They act bizarrely. They make statements that are irrational, that don't make sense, and they oftentimes tend to blame themselves for whatever has happened. I've seen this many, many, many times in the emergency department.
Does this happen moments after a stressful event?
Oh, yes.
Does it happen months later when you go on 20/20 or Nightline?
I've never seen that situation.
No. Does it happen a year later when you go and speak to documentarians and be interviewed? Is that the same kind of condition you see a year later, year and a half later?
A grief reaction can last years. It usually is very brief, but it can last years.
Now, when you looked at the clothes in this case, Mr. O'Keefe's clothes, you are aware that those clothes were swabbed for DNA traces, weren't you?
Yes, I'm aware that some of the clothes were swabbed for DNA.
Could we have Exhibit 147B, please? On the right arm, there were a number of different tears in that fabric that you looked at, weren't there?
Yes, there were a number of small round holes in that
You're
fabric.
aware, aren't you, that those holes were swabbed for traces of dog DNA?
Objection, Your Honor. I'd like to approach, please.
Okay, come on up. Longer than any of us wanted to do while you're sitting here. So we're going to continue what we're doing, but we will give you the morning recess. So let's say about a half an hour or so, okay?
All rise for the court, please. Close your notebooks, follow me.
Dr. Russell, you can step on this.
Oh, okay.
Thank you.
Sam, watch your step coming down. Follow me.
Jury is exited the courtroom, please be seated.
All right, Mr. Alessi, I'll hear you. Mr. Alessi, I'll hear you.
Thank you, Your Honor.
Excuse me, Mr. Brennan.
Mr. Brennan, can you remove, oh, okay, it's being removed.
Thank you, Your Honor. Attorney Brennan, just with regard to Dr. Russell, in open court in front of the jury, used the concept of DNA in this case. He has introduced it and brought it in for the very first time in front of the jury. He has done so intentionally. He intentionally brought up DNA. Based upon that intentional mention, the defense moves strongly, vigorously for a mistrial with prejudice. A mistrial with prejudice. There has been no mention in this trial of DNA with regard to the topic, with regard to what Mr. Brennan has raised. There has been none. Specifically, the prosecution had, in the first trial, had a witness, Terry Kuhn, with regard to DNA. For whatever reason, the prosecution has chosen not to bring that witness in who would testify perhaps to DNA. As a result of that strategic decision that the prosecution made, there's been no mention. I want to be very clear. The defense has been incredibly assiduous and meticulous about not mentioning DNA in any fashion, directly or indirectly. With regard to the hoodie shirt and the hole, the only thing that was adduced in direct examination was a mechanical function simply of Dr. Russell testifying that a dog tooth went in and came out and caused a certain mechanical effect on the yarn. Nothing even close to the mention of DNA. With regard to representations that Attorney Brennan has made that somehow there was a hearing that we were on notice, it is completely incorrect. Show me the hearing, show me the transcript where that has been discussed. The prosecution has also said, we're going to, or we always intended to bring on rebuttal Dr. Crosby, who would talk about the supposed absence of DNA, the alleged absence of it. The problem with that of trying to rescue the mistrial that the prosecution has caused with prejudice is that Dr. Crosby could never testify about such a topic, because I would object because there would be no foundation, because the prosecution strategically chose not to bring in the foundation whatsoever in this trial. The fact that they did it in another trial, or perhaps did it, is irrelevant to this trial, as Your Honor has admonished several times. What happened this is a new trial, and whatever happens in the first trial is the first trial. So in conclusion, Your Honor, because of the conduct of the prosecution, and specifically the intentional mention of DNA, the prosecution has put in the jury's mind that topic that is irremediable. That cannot be reversed. That cannot be cured. That cannot be ameliorated with a jury instruction. That cannot be dislodged. The prosecution has to suffer the consequences of its own intentional actions of bringing up that topic. Ms. Reed is entitled, under the Constitution, under the Massachusetts Declaration of Rights, to a fair trial. And what has just happened is antithetical, abhorrent to a fair trial. The only remedy is a mistrial with prejudice.
Okay, thank you. Mr. Brennan?
Inquiring of Dr. Russell about the absence of dog DNA is not only proper and permissible, it's essential, and the Commonwealth is entitled on cross-examination to explore theories and facades that the defense creates if there is actual evidence that undermines or contradicts the representations that they are trying to portray to this jury. Let's be clear. The defense is on notice that there is no dog DNA in the sweater of John O'Keefe. Let's be clear. The defense is on notice that we were not going to try to disprove all of their varying theories in our case in chief, but if they were going to propose theories that we thought were unsubstantiated, we would do so in rebuttal. It is clear these witnesses are on the witness list. More so, the conversation and examination of Dr. Russell is replete in the historical record of this case. Dr. Russell herself testified on December 12, 2024, that she did consider the absence of DNA in her opinion. She disregarded it, she discounted it, she created false theories about the potential destruction of it, but she did testify this was part of her consideration for her opinions. Again, on January 7th, 2025, Dr. Russell again discussed the absence of dog DNA in John O'Keefe's sweater. Now, it may be inconvenient, it might be hurtful for the defendant's theories, for the creation they portrayed for this jury yesterday, but it is not improper, it's not unconstitutional, it's not irrelevant, it's very relevant. It is powerful evidence that the Commonwealth has to undermine this idea that the linear, superficial abrasions on John O'Keefe's arm were somehow caused by a dog. They, on their case in chief, tried to create impressions about the cause of the abrasions to Mr. O'Keefe. The defense does not get to pick and choose what words the Commonwealth can or cannot use. They do not get to pick and choose what parts of Dr. Russell's opinions are important and not important. Because they chose not to emphasize, highlight, or discuss the absence of dog DNA on direct does not mean it's beyond the scope of direct examination. It means they did not want to talk about it because it was not helpful to them. There have been countless cross-examinations in this case where questions are asked beyond the scope of direct. This is not beyond it. It goes to the heart of her opinion. If I cannot cross-examine her, as proposed by the defense, about the heart of her opinion, she shouldn't give it. She shouldn't have an opinion, because you can't come in and just take the favorable factions for yourself and leave out reality. I intend on asking Dr. Russell about her opinions, about the role that the absence of DNA played. Also, I expect to ask her about her attempt to diminish or demean the DNA evidence, because it shows her inherent bias in all of her opinions, where she acts as an advocate, not as a scientist or a doctor. It is admissible evidence. We intend on using it. And when she returns to the stand, these are the very questions I'm going to ask her.
Your Honor, may I have a brief 1 minute?
Sure, go right ahead,
Thank you,
Mr.
Your Honor.
Wilson.
Your Honor, a key misstatement of fact that Attorney Brennan just made. He said that Dr. Russell talked in prior proceedings and hearings about dog DNA. The record is abundantly clear. She only did so in response to a question from Mr. Brennan. I have the transcripts right with me. She never raised it affirmatively. She gave her opinion that these wounds were to a reasonable degree of medical certainty from a dog. Mr. Brennan on cross said, did you consider, and this is in a prior proceeding, did you consider DNA? She gave her answer. She didn't raise it. I heard it. I was there. Your Honor was there. So this impression that Mr. Brennan is trying to give, that somehow the defense brought this topic up before, is incorrect. The second point, Mr. Brennan needs to have a good faith basis to ask the question. To have a good faith basis, he has to have some admissible evidence that he's got for it. He has no admissible evidence on dog DNA with regard to the arm. He knows he doesn't. He strategically chose not to bring that evidence in this case. Now he's saying he wants to use it. That would be improper in this trial for that reason. The other 2 points quickly. Mr. Brennan alleges an absence of dog DNA with regard to these wounds in the right arm. There was no swabbing of the wounds of the right arm of Mr. O'Keefe. That is a major, major investigative flaw in this case. That should not be befallen upon the defendant. Secondly, there are, with regard to the hoodie that was one, I believe, swab taken, and we don't know much about it, but what we do know about it is there are horrible, tremendous chain of custody and care with regard to the hoodie, conceded, virtually left on the floor of the ambulance, left on the floor of the hospital, carried around by Mr. Proctor for weeks, maybe even months, not submitted for testing for months. There are huge issues that prevent a fair determination about whether there was even proper determination of whether there was DNA or not. So in conclusion, Your Honor, the defense has never brought up DNA or alleged absence with regard to the right arm of the hoodie. It's always been the prosecution. We were meticulous and assiduous in not doing it here. The prosecution needs to live with the consequence of its action. This is remediable, and I respectfully submit warrants only one ruling respectfully, and that is this trial must be declared a mistrial with prejudice.
May I have 30 seconds?
Sure.
The defense can pound their fists and yell as loudly as they want, but they can't change truth and reality. Whatever the motivation is for wanting a mistrial can't be based on a claim that the prosecution raised DNA for the first time with Dr. Russell at the Lanigan hearing. If we actually look at facts and reality, rather than making false claims about everybody in the courtroom and everybody else who comes in here, what we'll see in the transcript, and this is the December 22nd, December 12, 2024 transcript, I direct the court to the direct examination of the attorney who just accused the government of raising it for the first time. Despite his words,
what page
we
are you
have page 83, line 21. We have page 122, line 14. We have page 124, line 14. These are the words of Attorney Alisi on direct examination. And there are more. But that is enough for the court to understand that the representations are wholly mistaken by Attorney Alisi. Wholly.
All right, thank you. We'll give everybody a half an hour. So.
All right.
I get it. And I mean, wasn't charged as an ag.
I get it, but
We have spoken to the complainant. I think I remember last time with this case, you wanted to hear from the complainant, just before you made a PC.
do you have anything else?
She's not, from what we can see, she's not. She wants to be around him. She said he had a gun,
Is he here?
No,
He's not
he
here.
waived his appearance.
Right. I remember. Yeah. All right. I'm gonna find no problem.
All right. Did you want to also then speak to Mrs.?
Come up, ma'am. You tested positive for meth. I can't let you go. That's just it's too much. You know, I have to revoke your bond, ma'am.
I don't do nothing, I'm prescribed.
I just tested you. You tested positive for meth.
Yes, sir, but the medication that I'm taking, that's why I've been trying to get.
Adderall doesn't test positive for meth. Show me a study, show me something that says Adderall tests positive for meth, but no, I don't believe that's a good, I mean, I'm in pre-trial, it's just. Have you heard of Adderall testing positive for meth?
I have not heard.
No. You're supposed to give, when you're being supervised by pre-trial, you're supposed to give them any and all prescriptions that you're taking so that they can cross-reference any positives with any kind of drugs that you're taking. Adderall doesn't test positive for meth.
That's not the only thing that I'm taking, sir.
So when she was in court the first time, she really was in a blank state.
I get it. I'm not talking.
And so at that time, when I asked about all the different prescriptions, she was very like scatterbrained. She was able to provide me with the prescriptions that they gave her when she went to the hospital for the assault.
So let's do this. Let's do this. I will give, you can give that to them so they can check it out to see if there's something that would possibly test positive for meth. But I just don't think there is. You're not, I've ordered you not to use alcohol, illegal drugs, you're not to use. There may be things that happen in our lives. You're supposed to find a good way to be able to deal with, PTSD. We all have it. We all do. But you have to find a positive way to deal with things. And illegal drugs is not it, especially when you're on bond for a very serious crime. So take a seat from the jury box. I will have them check it out to see what, if anything would, but
Just for clarity for the court, she's already provided prescriptions that she has when she went to test.
I don't know, maybe she has something different. And have you looked at all those prescriptions?
I mean, all that's been disclosed is two of the prescriptions.
Okay, ma'am, take a seat for me in the jury box. I know that the only reason you're doing this is to avoid jail. You can run, but you can't run forever. At some point, if you continue the way you are, you're really going to do some damage. Hopefully, not something that you kill someone, because, now you've dug yourself a little hole, but it's not so deep that you can't get out of. There are programs here where if you successfully complete this, if you apply, they grant you entry and you complete, this gets dismissed. What you're doing now is you're just pleading guilty to be done with this. I'm sure that there's no evidence that's even in. You may be found not guilty, but the evidence is not in. So you can't, this isn't Target where if you don't like it, you can just, you know what, I want to change my mind. I now want to fight the case. Once you plead guilty, this goes on your record and it will be there for the rest of your life. You can never undo this plea after today. Do you understand this?
I have a question about that. For the Nolo Con test.
No
It's
contest.
still, I'm still going to find you guilty. It's still going to reflect as a conviction on your record. You saying no contender? Most people would do that so they don't get sued in a civil court for a civil matter, right? It has nothing to do with this. It's still a conviction on your record.
And we discussed that, we discussed that. And there is discovery and we're just missing a little, the station video, Your Honor.
Once you plead, there's no turning around. Are you sure you want to do this?
And I went over it extensively with her as well, Your Honor,
trust
because
you.
I had
I know.
some questions, but
When you take a half-ass approach to things in life, you get a half-ass result. This will trail you for the rest of your life. Whenever you want to apply for government loans, when you want to apply for a new house, a car, when you want to get car insurance, what do you think a DWI is going to do? You have worked out an agreement that they're offering you 3 days in jail with credit for the 2 days that you've done. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. That's what I was saying. Once you plead guilty, this goes on your record and it'll be there forever. Is it true or untrue that you had a .15 or above, ma'am? Someone to find that that's true? There is a $6,000 surcharge that tacks onto you when you plead guilty to a DWI. I told you there are consequences. $6,000. And if you don't pay it, every $100 you owe, you sit 1 day in jail.
would you waive that fee, Your Honor, based on her indigency?
Why? Why would we give her yet another reward?
Because she has the issue, I think a lot of
I get
us.
it. But she's testing positive for dope that she shouldn't be. She's pleading guilty now to avoid skirt jail time. Why would it, another reward?
No, Your Honor,
Yes, that's exactly what we're doing.
not why. I have 2 children and I take care of them. I have left the shelter in Beaumont to come back to Houston so I can help my mother take care of my children. She can't do it by herself.
How on earth are you going to be taking care of children when you have this and you're testing positive for that? Why do you even have custody of kids? Don't. You need to understand that the apple doesn't fall far from the tree. In every single case that we see here with people with the issue, the apple doesn't fall far. Kids are just like their parents. They will emulate you in every single way. If you're nice, if you're smart, if you're easygoing, if you're patient, it all stems from, imagine you are the stalk of a tree, right? Your kids are the limbs. They grow straight, they grow beautiful into just grateful looking flowers, or they can be, you know, and this is my concern. You're testing positive for these types of things. You're taking the easy way out instead of addressing the issue head just up front. I'm telling you, if you don't, something catastrophic is going to happen. And God forbid, kids in you with your car, you know? If you ever get pulled over in the future, the officers, the first thing they do is they look at your record. If they see that you have this DWI and you have anything remotely funky on your breath, you're acting in an abnormal state, even the faintest smell of alcohol, it's probably not going to go well for you. Do you understand? So even if you've had a sip of alcohol, don't get into a car because you're begging for trouble. Do you understand? I'm going to waive the fee for you, ma'am.
Thank you, Your Honor.
I'm going to suspend your license for 90 days. Are you sure you want to do this?
Yes, Your Honor.
You don't want more time?
I think that the situation boils down to
I won't put her into custody, but I'll expect you to do like AAs every day. If you want
Did you want to do that?
to do this, I can give you time, but I'm telling you, I'm going to test you twice a week, so I know you're not using, and I want you to do NA every single day.
Can I talk to her, yeah? I'm gonna tell her.
I don't want you to rush in and make a lifetime mistake, because that's what you could be doing right now.
She would still like to go forward with her plea.
Fine. Far be it from me.
But she would like to acknowledge, though, that she did, take a deep dive into the offer, and she, appreciates that you're concerned.
Far be it from me to stop you. If that's what you want to do, then more power to you. Just understand you can only run for so long, and just don't leave a wake of destruction, because I'm going to waive it for you now. But if you pick up another DWI, it's another $6,000 fee. And now, from now on, it's a minimum of 30 days in jail. No more proverbial slaps on the wrist. Do you understand? And it's in the entire state of Texas. Don't matter where you go. You understand? This will trail you for the rest of your life. You can never take it off. Do you understand? All right. You're giving up the right to a trial, the right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. How do you plead to the offense? Guilty or not guilty?
Guilty, Your Honor.
I'm going to find you guilty, sentence you to 3 days in jail, credit for 2. I'm going to find the enhancement that it's a 15 or above true. I'm going to kill your car costs so you won't own anything. I'm going to kill the supervisory fee, but you come back. Get ready. I am suspending your license for 90 days. Do not drive until you get a license. Good luck to you.
All right, thank you, Your Honor.
All right.
Thank you.
Address bond.
Say it again.
I said I want coming out to address on bond.
Okay.
Tyree Lucas.
Know if he's going to post bond?
I think so. He's probably gonna ask for it to be reinstated. His issue was he lost his paper date on it, and then he went on the clerk's website, which was good. But he typed in first name, last name, comma, first name. That he called the courthouse, got transferred, but never got an answer. And probably should have done a little bit more than that, but that is what he did. He has a mental health concern, but he is back on there. He was taken up this day. But his mom is super involved.
That was my only other concern. It's like,
She's out of state, but she's very involved.
jail.
I have no speak for that one. It's a learning experience.
We have them for a reason. You know, we don't ask much from you. You know, the only two things we ask, we want our streets to be safe. And if you pick up a case, you got to show up to court. And when you do, good things happen. When you don't, this is what happens. Your lawyer's asking for me to reinstate your bond, and you've missed court once, which is not the end of the world. But my only other issue is I don't want to give you a bond and you go to the street. Because if you're going to the street, nothing good happens on the streets. So tell me about home. Where's he going to go? What's he going to do? I'm not letting him out to the street. I'm going to tell you that now.
He has two places he can go. He stays with his girlfriend off Broadway Street, or he can go to his grandmother who also lives in town. He was staying with his girlfriend prior to this, and
I like grandma better.
Yeah, grandma's
I was
certainly better.
staying at both. For school and work, I was staying at both.
Yep, so he was staying at both, a little bit back and forth. He does staffing work, so while it's not a full-time employment, he does have jobs, but they are kind of come and go depending on the company's availability.
The terroristic threat is who? Who's the complainant?
Grocery store.
So it's not
No,
girlfriend.
no family members, so.
That's right, Judge. It's at a school.
A convenience store or
Yes.
anything? Okay, so do me a favor, please. Will you, if you don't be so kind as to reach out to grandma. If she says that he can stay there, then I will reinstate his bond. And then, but I'm gonna order him to stay there. I don't want you going anywhere else, and I don't want you out in the middle of the night, and you're not to go to the store, and I don't want you to be in possession of weapons. No alcohol, no dope. Do you understand? I'm gonna test you like crazy. If I reinstate your bond, it will not happen again. You get one get out of jail free card, no more. Do you understand?
I understand that.
Okay. Just go, guys, go.
Yeah. Thank you, Your Honor.
All right. Okay, ready? Yes, sir. You also to the judge.
Do we still have YMAC available?
We do.
We are going to do this the easy way, or we're going to do this the hard way. If you think that you're just going to be able to skirt by and not do anything, it's not going to work. That's the way you've been doing things here now. For 397 days. We have available to us a boot camp that is about, 9 months?
Yes, sir.
It's called Young Men About Change. It's one of the resources that we have for those who just refuse. Look at me. I want you to hear me. And I want you to hear me loud and clear, Mr. Jones, Mr. Joseph, because so far, you've done nothing of everything that we ask you to do. It's not going to continue. Do you understand?
Sir.
What we're doing now is you are being placed on the young adult caseload. This here is an opportunity for you to literally have people bend over backwards to help you. They will help you get a job. They will help you with resources with whatever you need. So if you're unable to follow through, it's all because of one person. You cannot blame others. It's if you really want to do it or not. And if you don't, and I'd like to keep it close because I want a status update within a month.
Okay.
To see what he's done, if anything, and if he hasn't, a motion will be filed. And Young Men About Change is a very big possibility. And I mean, I want you to understand this. Can you please let him know everything that they had said earlier as far as what all will they help?
Oh, yes, so they're gonna help you get your ID, they're gonna help you get, whether GED readiness, or if you wanna get your high school diploma, they're gonna help you with that. and then enroll you in a vocational or trade school. That's the things they're gonna help with.
No, keep it.
Mr. Joseph, a vocation or trade school is about the best thing because you can seriously make a ton of money, $20 to $30 an hour if you get the right job. You could literally be raking in the money, thousands of dollars a month. You're charged with burglary of a motor vehicle, you're facing up to a year in jail and or a $4,000 fine.
Dismiss the burglary judge and proceed on the unlawful carrying of weapon case.
I don't know if you understand how much they're helping you. They're dismissing the burglary case. You're going on the weapon case. Because when you have that burglary case on your record, no one hires burglars. Get it? They're literally everyone here's bending over backwards to help you. Do you understand? Forfeiture of the weapon, correct?
Yes, sir, Your Honor.
The agreement is a 9-month deferred. This is a type of probation that if you complete it successfully, you do not end up with a conviction. You give up nearly every right known to man by entering into this agreement, Mr. Joseph, where if you violate this agreement, 1 iota, a warrant for your arrest will be issued. We will have a hearing. You're looking at either a year in jail or any other whole host of possibilities, including a boot camp. Do you understand?
Yes, sir.
For you to successfully complete this, you must do a thinking for a change. You have already done the TRAS, which recommended the young adult caseload, so that's why we're doing this. No drugs, alcohol, random testing, substance abuse treatment. $25 hours of community service. If you get into a trade school or vocational school, I'll waive the community service for you.
Thank you, Judge.
You must get the GED. You must get your ID card and forfeiture of the weapon. Is this how you understand it? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, there's no turning around. You understand?
Yes, sir.
How do you plead to this offense, guilty or not guilty? I'm not going to find you guilty. I'm going to withhold that for 9 months. I'm not asking for much. Get it done. Make us proud. Be something. Look.
Garcia?
Waive all his fees. Okay?
How the birds out?
Judge, I have Ms. Aristelci on the docket, and she had the drug test on Friday. She was rolled to today. And it came back negative, Judge.
Yes, sir. It came back something negative.
Well,
And Judge, I've submitted the DWI PTI application and the character letters. I'm just waiting to hear back.
fantastic. Great job.
Trying to.
That's awesome. No, great. That makes me very happy. That's awesome. Good job. So just keep it up, one day at a time, you know? And we all get stressed out. I have a friend that punches trees when he gets so upset, right? His calcified knuckle looks like it's gross, but that's what he does. Everybody has an out. Find it. Something.
Trust me, your head is in my mind
something
every time.
Like productive, helping perhaps exercise. That's what I do. I have 4 kids. They drive me up the freaking wall every single day, but I run. That's how I deal with it. Great job. So, you wanna?
Maybe get a standard reset, Judge, and.
Sure. You're gonna get tested again, so just be careful, right?
We can schedule the TRAS now, but she's not been approved yet. I guess we might want to wait for her to be approved, or.
Yeah, I'd probably say so, because now we're seeing a lot more denials than ever.
Oh, we are? Okay.
So, yeah, I don't wanna,
Put the cart before the horse. Right.
yeah, can we wait the fee on that?
They'll have to do like a financial affidavit and all that.
Just the way the fee on the TRAS?
Oh, I can wait to be on the
Okay,
TRS.
please, yeah. let's wait regardless, because I don't want you to have to go through this whole dog and pony show if not. So let's set it like 2 weeks, 3 weeks.
Sure.
And then we'll come back and we'll see if it's.
See if we get a response. Okay, I'll do that, Judge. Just have her take.
Thank you, Judge. My son follows you on TikTok. I don't want him to see me out there.
Just take a seat real quick. Hey, Judge, I have one more. This is an off docket, if I can give you the cause number.
All right, you were Mr. Jefferson. Mr. Jefferson, you're charged with tampering with a government record. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On April 21st, 2025 in Harris County, Texas, an officer observed a motor vehicle with temporary tags and ran the tags through the TCIC NCIC database and came back with no record. Traffic stop was conducted and the defendant was identified by his Texas driver's license. The event stated he purchased the tags from a dealer off Bissonnette Street for $95. The officer went back to the patrol vehicle and ran them through the database and found that the vehicle did not have valid insurance and that the marks in the vehicle returned showed registration invalid, salvage vehicle title issued, and salvage vehicle title damaged, making the vehicle unsafe for the roadway. The officer also.
Wait, you're saying it was salvaged?
Yes,
Is that
sir.
what you think? Okay.
The officer also noted that the QR code on the temporary tag scanned back to tagstexasdmv.com, which is not the Texas government affiliated website. When the officer went to detain the defendant, he tried to backtrack and said that he bought the car and never bought the tag. The officer also ran the vehicles again through Carfax and thought the vehicle had a salvage shuttle.
All right. Mr. Jefferson, I'm going to find that there's probable cause to go forward with the case. Can you see if he has a valid license, please?
Yes, sir.
If you do not have a valid Texas driver license and liability insurance, you're not allowed to drive. And that is a condition of your bond. If I find that you do, I will put you in jail. No more PR bonds. Do you understand?
So,
He doesn't have an eligible license.
Okay, I don't care what you're doing. If you want to drive, just go get insurance. Imagine you get into an accident, you kill someone, they're going to come after you for $50,000.
I already got it, already.
Just stop. You have the ability to hire a lawyer, Mr. Jefferson. Okay, we're going to give you an application. I'll look to see whether you qualify. I need to know everything about you, whether you're working, what kind of money you make, and then I'll see whether you qualify. We're going to have bond conditions created for you. Do not leave until you sign them. So for now, I'll have you go to Victoria Center Reset. He's going to give you an application, then we'll just take a seat from the bridge here. Good morning, Ms. Santos. Ma'am, you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be pointed to you.
Yes.
Oh, no, it's an assault of a family member,
Yes, sir.
right? Okay, yeah, sorry.
On April 21st, 2025, in Harris County, Texas, officers were dispatched to an assault in progress call. The officer arrived and made contact with the complaining witness who stated that the defendant and him are in a dating relationship. The complaining witness stated that the defendant caught him watching pornography and got angry. The complaining witness said that the defendant started to argue with him, and that's when the complaining witness tried to leave the defendant and bit him in the chest, causing pain. The complaining witness advised that the complaining witness trashed the apartment and would not let him leave. The defendant admitted to trashing the apartment and said that she was upset because she found naked women on the complaining system.
Okay. Ms. Santos, I'm going to find that there's sufficient probable cause to go forward with your case. There's a protective order that has been issued in this case. I would get to know it. If you do something to violate the protective order, the state can and probably will file a violation of protective order against you. It's one of the worst cases you can pick up. Do we know whether he wants to have contact with her? State.
Just a moment, Your Honor. So we've not been in contact with the complaining witness yet, Your Honor.
No?
We've
Okay.
attempted to reach out, but
I don't know if he wants to have contact with you, so until I know, I'm ordering you not to have any contact with him. You're also not to be in possession of weapons. Do you understand, ma'am? If you violate these conditions, a warrant for your arrest will be issued. You will go into custody and you will have your bonds. Do you have the ability to hire a lawyer?
Yes.
Okay. I can appoint you a lawyer today. So what I'll do is I'll have you go to Victoria Center, reset. After that, I'm going to have you take a seat in the jury box. We will create bond conditions for you. Do not leave until you sign them, and then we'll have you talk to a lawyer shortly, miss. Please, I already have them. If you bring your client up, we need to have them sign.
He did already. He signed already.
Oh, you did? Okay, did you sign? Okay, come on up. You know, one day, it may not be today, may not be tomorrow. One day, you're going to say, why didn't I get that thing done? You had the opportunity to get this thing dismissed, and now you will end up taking, now you will end up taking a conviction. This will go on your record. It will be there for the rest of your life. Even after you die, it's still going to be there. The next time you get pulled over, first thing an officer does, they're going to look at your record. They see this DWI, they roll up to your window, they smell alcohol or dope. It's probably not going to go well. Do you understand? From now on, what we're doing today, no more proverbial slaps on the wrist. It's a minimum of 30 days in jail. Any new cases that you pick up, not to mention that, you pick up another DWI, it's a surcharge of around $6,000. And if you don't pay it, every $100 you owe, you will sit 1 day in jail. Do you understand? You're giving up a lot of rights by entering into this agreement. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, like I said, this will go on your record. It's going to be there for the rest of your life. There is also a $3,000 surcharge that tacks onto this. Is your client indigent, Mr. Boyan?
The owner is, it appears, because he's not been able to even pay the attorney's fees. So I believe it is.
What do you do for a living?
I'm self-employed, I do wood fencing.
You're allowed to make mistakes, Mr. Soto.
Yeah.
But when you make mistakes that you endanger other people's lives, we really rain down on you and we bring the pain. So if you want to get lit, if you want to have 32 beers, 52 shots of tequila, don't get into a car. For $40, one button will take you wherever you want to go. Do you understand?
Yes, sir.
Have you pleaded this offense guilty or not guilty? I'm going to find you guilty. I'm going to sentence you to 3 days in jail, give you credit for the 2 days that you've done. I'm going to suspend your license for 180 days. I'm now going to waive the $3,000 fee that would normally apply to you. But I'm going to tell you, you come back with another one. It's a minimum of 30 days in jail and a $6,000 fee. Do you understand?
Yes, sir.
Good luck. Please see the clerk. James, what happened?
So apparently, Ms. Ersdelsi was denied PTI because of her bond violations. They have a brand new case note in there. So I'm gonna email Ms. Geis and see if there's any way, what'd you say, Judge?
I'm going to appeal it.
Judge, if there's any, maybe more additional character letters they,
Whatever you need to do.
okay,
I mean, it's not old, right?
right, I think it's a couple.
It's all, so take your time.
Yes, Judge, I'm gonna see if we can, if there's any way we can work around that. I've actually, this is the first time I've encountered denials for bond violations, but I guess they do add.
Time I've seen it.
Okay, Judge, and I have one more whenever you're ready.
What is it?
It's a 253-1383. Judge, this is Mr. Hubler. I don't know if you remember this one, Judge. He's here. He has a warrant out. I believe the offer was for him to.
Come on, Mr. Hubler.
Yes, he had completed his drug rehab, and the offer was originally, if they'll honor the same offer, was to dismiss it with completion of drug rehab.
Mr. Hubler comes when Mr. Hubler wants to come.
Well, Judge, he was in drug rehab.
I didn't have access to a phone.
Show me. Let me see.
This is the big one. And if you look at his mugshot, he looks a lot different now.
7 months clean.
Good job.
Thanks, sir.
Great.
I'm planning on working for the Salvation Army to help other people to get clean and sober and keep myself clean and sober.
Great job. Really. Great. You know, we just need to know where you are. I get it. So you don't have to say anything. I get it. And I'll recall the warrant. Do you mind?
And he did have me approach off docket, but he was in warrant status. He wasn't here, but he did have me try to address it without him present.
Good job.
While he was in
Yeah, I'm
drug.
proud of you. One day at a time. You know, just keep up the good work. You know, we're behind you. We want to support you as much as we can, you know, and of course, we're going to recall the warrant.
That's what I was trying to see if we can do our original.
I'm gonna see if Blaze will, because you probably need to speak to Blaze about that.
Yes, just hang tight with us. I'm going to have him talk to the chief, see where we go from here. Oh, it's not an adoption. It's
No, Judge, it's off.
just hang tight. Yeah. Ready? I can give you that.
Please be seated for the session.
All right, so the motion for mistrial is denied, your rights are saved, and Mr. Brennan, you can continue with this line of questioning.
Nor I did not address sidebar the other issue that's under court's consideration regarding Dr. Walsh's opinion.
Yeah. I don't see it without a foundation. So if you can build a foundation, I'll consider it. I do not believe that foundation has been laid yet.
I would expect that foundation would need to be substantial, specifically whether or not it was relied upon by the witness.
Yes.
Could you do that outside the presence of the jury so that I don't ask the questions in front of the jury?
Oh. Yes, but not right now. They're on their way. All right. Do you have enough?
I'll work around it.
Okay.
I'll work around it.
Your Honor, I would object to it being done outside the jury, that it should be done like I've had to do with several witnesses in front of the jury.
Okay, if that's what the defense wants. Are you sure, Mr. Alessi?
Oh, wait, I'm sorry, let me confer with my. Yeah, okay. I am going to, yes, Your Honor, we are going to.
Oh, dear.
Thank you, Your Honor.
Okay.
They're on the way, Your Honor.
Thank you.
I'll be done very quickly, so I'll have to make that decision.
Is are the lunches here? Probably not. Okay. Are they still over there? Have they already? We can hold the jury up now. I don't know how far along they are.
Did you start yet, or can you turn?
Just if they're downstairs on their way up, I don't want to stop them.
I could do it in 2 questions.
Yeah, please.
Oh. Excuse me?
They're still over this way.
Great. Okay, they're going to stay.
Your Honor, if it might help, obviously, I'll be subject to whatever Your Honor does. Based upon if Mr. Brennan only has 2 questions, I may have 30 minutes that I could, most 35 to finish up whatever redirect that I have, if that affects Your Honor's scheduling for the jury.
I just didn't want to stop them if they were on their way. They haven't yet gone downstairs.
No, I don't think they made it downstairs.
All right, we'll do this now.
Be quick.
Okay?
Dr. Russell, during your review of the case, did the defense offer you the report of John C. Walsh, MD, Deputy Medical Examiner?
I didn't hear the whole
I'm sorry.
question.
During your review, the defense provided you materials. Did they provide you the report of John C. Walsh, MD, Deputy Medical Examiner?
I don't recall.
May I approach?
May I-
Yes. Can we turn the fan off over here, Tony, please? Or- Thank you.
Dr. Russell, did you ever review or receive that document from the defense?
Oh, yes.
And regarding Dr. Walsh's opinion, did you consider that when you formed your ultimate basis that the wounds on Mr. O'Keefe's arm were consistent with the dog bite?
Yes.
Did you disregard it or agree with it?
I disregard, I disagree with his assessment.
Thank you. Sorry, I'd like to inquire.
Your Honor, I would object. This is the same exact issue I had here with because where witnesses disregarded it and I was not allowed to pursue questioning. So I do not believe, under the standards that's been set in this trial, that a proper foundation's been set.
What do you say about that, Mr. Brennan? How is this any different?
Pardon me?
I'm talking to Mr. Brennan. How is this different with this witness's analysis?
Because they specifically opened the door when they had her vouch for her own credibility, extolling her uniqueness and ability to determine that these were dog bite wounds. And so when they opened their own door to vouch for their own credibility and suggested that they're the only person or a limited person in the entire country that can do this, they should be confronted that they are not alone. There are other experts. And so this isn't affirmatively bringing it in. This is when the defense continually opens the door and creates these issues.
What do you say, Mr. Lessie?
Thank you, Your Honor. My response is this. I'll give 2 quick examples. Dr. Welcher, Trooper Paul, Dr. Squirty Bello. They talked and opened the door under Mr. Brennan's theory of opening the door widely. They even had, as part of their direct examination, documents in Dr. Welcher's slide that mentioned Dr. Squirty Bello. You'll recall that slide. They even had material from the CARS team with a file named Trooper Paul.
I'm not letting it in.
Thank you.
All right, I'm not letting it in under that, Mr. Brennan. So you can mark the report if you want, but for that reason, I'm not, for the reasons stated by the Commonwealth, I'm not letting it in.
I don't need to mark it.
Okay. All right, thank you, Hunter. An objection. Where are we? Is it in evidence now?
It's not yet, it will be.
Okay.
Could you just say it in evidence?
The DNA. It's not, right?
It is not. And
Okay.
is there any question?
Yeah. Yes, it's open. I denied the motion and allowed the line of inquiry.
Back in session, you may be seated.
Jurors, I appreciate your patience. All right, Mr. Brennan.
Thank you. Good afternoon, Dr. Russell.
Good afternoon.
Dr. Russell, we were talking about your differential diagnosis and your opinion that Mr. O'Keefe's abrasions on his arm were not consistent with impact or collision with a car. I was asking you specifically about some of the things you may or may not have reviewed before you formed your opinion. You looked on direct examination at a photograph in Dr. Welcher's presentation, and it had a photograph of a person who had been hit and died as a result of a collision. Do you remember that photograph you looked at?
The photograph of, which one specifically?
There was a gentleman
I've
lying
seen-
on the ground, his face was redacted, and there was
Oh,
some
that
di-
one,
Do
yes.
you remember that one?
Yes.
And when you discussed that, what was the reason? What was your point in discussing that?
I was answering questions.
Do you know what the point was, what you were trying to deduce or
No, I was
suggest?
just answering questions.
Okay. You have stated before that one of the reasons you do not believe that the injuries were the result of a collision or impact with the car is because there were no lower body injury breaks. Do you remember that?
That's one of the reasons, yes.
You would agree that a side swipe or a clipping collision is different than a front or a back immediate impact, like being run over. There's a difference, right?
In general, yes.
When you talk about the absence of lower body brakes, do you have any studies about the frequency or the likelihood of lower body brakes in a clipping impact as opposed to being directly run over?
No.
When you looked at that photograph that was shown to you on direct examination, did you look at the actual injuries that were listed for that gentleman and see that there were no lower body brakes?
I looked at all the injuries, yes.
And did you recognize in that photograph and slide that there were no lower body brakes?
Yes, I did. There were major internal injuries, however.
When you considered the information in this case, did you have an opportunity beyond that photograph to look at Dr. Welcher's videos about impacting a vehicle driving backwards? Did you watch those videos?
I saw an image. I saw an image.
Did you see a video when Dr. Welcher put blue paint on his arm and showed the height and the location when it touched Alexis? Did you see that?
Objection, Your Honor.
I'm going to allow that.
Yes, I saw that image.
Did you consider what's called the text stream data? Do you know what text stream data is?
What?
Text stream, the black box that shows the operation of a car, how fast, how slow, acceleration. Did you look at any of that information before you formed your opinion?
I looked at it, but I honestly did not understand it.
Did you ask anybody to help you interpret that data before you drew an opinion that the injuries were not consistent with the collision?
Well, first of all, my opinion came long before that report ever came out. So the answer to that is no.
When you have an opinion, if there's new evidence that is contradictory or different or maybe undermines your theory, do you have an open mind to reconsider your theory?
Yes, I do.
Did you want to understand that information about the text stream data and the information that was available regarding this allegation? Did you want to understand that before you came back and offered the same opinion you had before that information was available?
I didn't understand it, and I didn't know that if any of the attorneys understood it, actually.
Did you know anything about Mr. O'Keefe's cell phone data when you were drawing these conclusions about when his last movements were? Did you learn anything about that?
No.
Did you know about any type of DNA testing on the defendant's rear taillight area?
Yes.
And did you know about any hair found on the car?
Yes.
Did you consider those things when you excluded the collision or impact as the cause of those wounds?
Well, I considered that. However, my understanding is he had been in and out of that car, on many occasions, and so therefore there would be reason for either skin cells or DNA or possibly other, parts of, hair, fabric to be on that car.
So when you consider testing your conclusions, do you look at it as an advocate or do you look at it as a scientist or a doctor and try to value how little or how strong that evidence is?
I'm looking at it as a neutral party, a doctor, a scientist.
So you're not looking at it as an advocate to try to discourage the strength or weakness of evidence?
Excuse me?
You're not looking at it as an advocate? You're looking at it as an independent professional?
I'm not an advocate at all.
When you talked about John O'Keefe's sweatshirt, can we put that up, Ms. Gilman, please? You identified or discussed some of the tears to the right sleeve of Mr. O'Keefe's sweatshirt, didn't you?
We discussed one puncture to the right sleeve, yes.
Having an interest in dogs and dog bites, certainly you're aware in your experience, when a dog bites, it creates quite a bit of saliva, doesn't it?
It can.
It can actually, a dog can froth, is what they call it. Excessive saliva when it's in the moment.
Some dogs, yes.
And some dogs, they can shed hair, especially when they're interacting with other objects, don't they?
They could.
Hair is considered trace evidence, isn't it?
Yes.
And saliva contains important items sometimes like DNA, correct?
Yes,
And that's considered oftentimes very important trace evidence.
yes,
And Dr. Russell, are you aware that one of the criminologists took swabs of holes on the left sleeve of the sweatshirt?
Objection, Your Honor.
No, are you aware of that?
yes,
You've heard of UC Davis, haven't you?
yes. And in reference to that previous question, however, the swabbing was done many weeks after the death, and there were images of clothing on the emergency room floor. So, yes, I am aware that there were some swabs taken at some point.
Is that gratuitous answer part of your advocacy or part of your medical objective opinion?
Objection, Your Honor.
Sustained.
And so you're aware that these holes were swabbed to send a sample to UC Davis, aren't you?
Yes,
UC Davis, do you understand they specialize in dog DNA?
animal DNA, I believe.
And you also know, in giving it before you gave your opinion, that when they were tested, there was no dog DNA found in any of the samples. You knew that, right?
Yes,
In fact, what was found was pig DNA,
that's correct.
and there's no identification where the pig DNA came from, is there?
I don't think so.
So when you saw the information, after you claimed there is a dog, prove it, John O'Keefe, when you saw the information that they were swabs done of those holes and the results were no dog DNA, did you consider that before giving your ultimate opinion?
Yes,
And in fact, you've tried to discount the significance of that evidence in the past, haven't you?
yes,
In fact, you have made claims about that evidence candidly with no foundation whatsoever, haven't you?
I explained why there could be no dog DNA found.
You were claiming that it was inconsequential because a number of speculative reasons, didn't you?
Objection, Your Honor.
So the objection's sustained. You can ask it differently.
When you were discussing the absence of dog DNA on Mr. O'Keefe's sweatshirt in the past, were you trying to make suggestions that perhaps the samples could have been tarnished or compromised in some way?
That's one possibility, yes.
As a independent, objective expert, should you deal in possibilities, or is it a better practice, best practice, to deal with objective criteria in the form of actual opinions to a reasonable degree of certainty?
It would be best to go through a process to determine, or at least come up with a list of reasons as to why dog DNA was not found. There are a number of reasons. You know, if you have a test in medicine, you expect it to be positive, and it's not positive, you go through a process of trying to figure out why the case is that way. There are many reasons why there could have been no dog DNA found.
When you first gave your opinion, you didn't even know about that DNA testing, did you?
Not initially, correct.
But then once learning about it, you were not willing to reconsider and change your opinion about the source of these scratches. You maintained the same opinion you had before, correct?
I reconsidered, however, my opinion did not change.
What you suggested is there's possibilities, is the word you would use, possibilities why there were errors with the DNA, yes?
Yes.
You can't tell us anything based in fact. Wait,
No.
I'm sorry.
Sorry.
You can't tell us anything based in fact to support the claim that something was wrong with the testing of this DNA, can you?
Not in fact, but again, you have to go through a process. If you expect a certain diagnosis or a certain finding on a lab test and it doesn't materialize, then you wonder why, and you want to know, was the test done correctly, was the specimen handled correctly, et cetera, et cetera. There's a process.
And in that process, you found no evidence whatsoever, none, zero, to support any claim of compromise of that DNA process, did you?
Well, ideally, the swabbing should have happened immediately or very soon after the incident. So there was a delay in processing or swabbing to begin with. And then, of course, I don't know about the transportation or the chain of custody.
You were a medical examiner, weren't you?
Yes,
When you were a medical examiner, when you examined a person or their body, you did everything you thought was reasonably necessary based on the information you had, correct?
yes,
Did you know at the time Dr. Scorbello did the autopsy, there was no claim whatsoever that a dog caused these wounds?
yes,
Did you know that claim didn't come about until over a year later?
no.
And did you know that in response to that claim, that's why this was done at a later time? Did you know that?
Still, for a complete investigation, this should have been considered by investigators early on.
Even where there was absolutely no claim or evidence whatsoever that a dog caused these wounds?
Well, again, a complete investigation.
You can't tell us one step that went wrong with that DNA process, can you?
The process, no.
In fact, you have admittedly very little experience with DNA.
I have little personal experience with DNA.
And yet, although you're not an advocate, you are willing to advocate trying to undermine the strength of that evidence, aren't you?
No, I am a scientist, and I'm trying to understand why it could have been negative.
As a scientist and providing a medical opinion, do you try to exclude in your differential diagnosis all other reasonable causes of a wound?
Generally, yes.
And did you do that in this case?
Yes.
Now, when a dog bites a sweater, would you expect that it would leave DNA?
Yes.
When a dog bites a sweater, you would not expect it would leave little fragments of taillight shards in clothes, would you?
Correct.
And so in this case, when you were developing your theory and differential diagnosis and excluding causes, did you consider that when Mr. O'Keefe's clothes were scraped, his pants and his shirts and his sweatshirt, what was discovered were minute, small fragments of broken taillight that came from the defendant's motor vehicle?
Objection, Your Honor.
I'm going to allow that.
Did you consider that?
I didn't know that at the time.
Could we have 201D, please? Dr. Russell, this is a photograph.
Okay.
Dr. Russell, were you aware that very small fragments, shards of plastic that match the broken taillight of the defendant's Lexus were found when criminologists scraped Mr. O'Keefe's shirt and sweatshirt?
Yes, I became aware of that.
Did you become aware of that before or after you came to your opinion and conclusion that Mr. O'Keefe's arm abrasions were not caused by a collision or an impact?
After.
And when you learned that, did you get a chance to see this photograph to see how small many of those pieces were?
Yes.
And would you agree that broken plastic, like broken glass, can tear fabric?
Yes,
Would you agree that broken plastic, like broken glass, can rub up against a person's skin, and if enough friction is caused, it can cause abrasions?
yes,
Would you agree that if fragments like this were randomly in the sweatshirt, that it could cause cuts or abrasions to Mr. O'Keefe's arm?
I don't believe that fragments that are randomly in the sweatshirt or clothing would cause the parallel abrasions, the pattern of the parallel abrasions that we saw in the arm.
Do you know how Mr. O'Keefe fell to the ground and what movements his body and arm made as he fell to the ground?
Not definitely.
You don't know?
How? No.
Do you know how much distance or little distance he moved when he was on the ground?
Yes, approximately, I think it was 20 feet. I initially heard 60, but around 20 feet, I believe.
You think, do you know where his body was found on the side of the road?
Yes,
Do you know if his body, before it rested, moved or slid on the ground?
yes, it did.
And it's your opinion that fragments like this could not have caused the superficial abrasions to John O'Keefe's arm?
You know, in reference to that last question, actually, that I don't know that there was a collision, but I know that it's alleged that there was movement of the body after the collision.
I wasn't asking about the collision, I was asking about his body. Are you telling us to a reasonable degree of medical certainty that these type of fragments that were found in his clothes could not have caused the superficial abrasions on John O'Keefe's right arm?
They can cause superficial abrasions, but not in that pattern that we saw on the arm.
I'm going to ask you the question again. Are you saying to a reasonable degree of medical certainty that these fragments did not cause the superficial abrasions to John O'Keefe's right arm?
Correct.
I have no further questions.
Okay. Mr. Alessi?
Thank you, Your Honor.
Okay.
Thank you, Your Honor.
Okay.
May I, Your Honor?
Yes.
Thank you. Your Honor, I would like to have published what is in evidence is 201A, and then I'm going to proceed after that with 201E.
Okay.
Dr. Russell, I have up this exhibit, and with regard to the questions of Attorney Brennan that he just asked about these alleged shards, can you tell the size of them from this depiction?
I don't even see any shards in that depiction.
Can you read that slide and see the handwriting that is there?
Yeah, it looks like clear app plastic collected from 7/18/18. There's another date over to the left side, and then it says AMV 6/29/23.
Right, and if Mr. Wolk, you could go back, can you determine at all from this whether the shards are microscopic or not?
I cannot see any shards.
All right, let's go to 201E. With regard to this depiction, do you recognize what is in this depiction?
It looks like irregular, red-colored pieces of debris.
Thank you. And do you recognize the ruler above those pieces?
I'm not sure if this is the same ruler as in the previous image, but there does appear to be a ruler.
If we could go back to the previous slide, does that at all assist you in determining whether or not it's the same ruler?
Not exactly, but there are similarities.
So let's go back to, flip back to the next slide. Does the, what is up in black help you reach any conclusion about whether those pieces are microscopic in size or not?
Well, so those are, again, I'd like to go back, but I think those might be 16th or 32nd of an inch if we're using the same edge of the ruler. Those pieces that are depicted are not microscopic because we can see them with our eyes, but they're extremely small.
All right, so they're extremely small. You've asked, you want to go look back at the ruler. Does that further assist you in your analysis as to the size of these pieces?
16, so those looks like they're maybe a 16th of an inch or less.
Okay, so let's go back, Mr. Wolk, one more time. So these pieces are a 16th of an inch or less, correct?
Yes, if we're using the same ruler.
Right. So with regard to, and if we could, Mr. Wolk, now go to Exhibit 1. Attorney Brennan asked you several questions with regard to whether those 16th of an inch or less pieces could cause these types of abrasions. You have addressed this issue, but I would like you to answer whether those pieces, a 16-inch or less, could cause, now knowing the size, whether they could cause these abrasions, including with regard to this pattern.
I don't believe so.
And with regard to that answer, how do you come to that conclusion? What is your thought process?
Okay, again, there are multiple parallel abrasions. So these pieces would need to be lined up in a certain configuration to cause those abrasions, and they'd have to be oriented in nearly the same direction because many of these groupings of wounds, and if I may use the pointer, are oriented in this direction a little bit, well, anatomically a little inferior to superior, ever so slightly this way. So they're oriented in the same way. So not only would they, those abrasions are rather large for those tiny pieces of plastic or glass, but they'd have to be oriented in a certain way to cause those wounds.
As an emergency department physician, as a forensic pathologist, what is the likelihood, if any, that those shards could cause those wounds?
You have to ask it differently, Mr. Mason.
Dr. Russell, please state your evaluation and conclusion and the basis for it as to whether those shards of glass, or excuse me, shards of plastic, 1/16 of an inch and less, can cause those abrasions on and wounds on the right arm of Mr. O'Keefe.
I do not believe that they could have caused those wounds.
Is that a close call for you to come to that conclusion?
Not at all.
You were asked several questions by, please keep that depiction up, Mr. Wolf. You were asked numerous questions by Attorney Brennan where he wanted you to go section by section by section and evaluate each. He grouped these, I think, 5 or 6. Do you recall that questioning?
Yes.
Is that a scientifically proper way to evaluate this wound to determine whether or not it is from a dog? Is that a proper methodology to look at each individual section only?
No.
How, at a scale, is it improper to evaluate them that way under your methodology?
Sustained.
Dr. Russell, what is the proper way to evaluate the wounds on the right arm to determine whether or not they're caused from a dog?
To look at patterns, because individual wounds can vary, but the pattern is what is significant.
And on your direct examination, did you go through this method that you just described, a pattern and pattern recognition? Did you go through that in some detail and discuss that?
Yes.
Now, you were asked questions by Attorney Brennan, and in his questions, it was asserted that you don't have a standard, a published standard. Do you recall that questioning?
I'm going to allow it.
Do you recall the question asking whether you had a standard to reference for your methodology? You recall that questioning?
In reference to dog bite wounds, yes.
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 And with regard to the question and assertion in the question with regard to a methodology, you referenced studies and as part of your answer. Do you recall that discussion with Mr. Brennan?
Yes.
Do those, and are those studies peer reviewed?
Yes.
And give the name, please, again, that we had gone over on direct, but give the name of the lead authors of each of those studies.
Yes. So one of them was by Dr. D. Munich, and the other one was Dr. Pollock. And by peer review, that means that it's the article was reviewed by other physicians in those respective specialties
So
of
if we
the
could
authors.
I'm sorry to interrupt you, Dr. Russell.
I'm
Have you
sorry.
finished?
The specialties of the authors, yes.
We could take that down for a moment. Your Honor, may I approach, please?
Okay.
If I could have, Your Honor, for Madam Court Reporter, exhibits marked for identification PPP and QQQ.
Right.
And I'll start with PPP if I could, please. Thank you, Madam Court Reporter. May I present PPP to the, thank you, Your Honor. Dr. Russell, you have before you PPP. Is that the study with the lead author, Dr. DeMunich?
Yes.
Do you recall Attorney Brennan in his questioning asserting that you had no basis and there was no support for your methodology of pattern recognition? You recall that discussion?
Objection.
Sustained in that form.
Do you recall questioning on the cross-examination by Attorney Brennan as to your basis for a methodology in terms of pattern recognition with regard to dog wounds? Do you recall that?
Yes.
Can you please take a look at exhibit PPP for identification and identify whether there's any section in that study that talks about and documents the methodology that you used in that study?
Yes. So this is an article that was published in the International Journal of Legal Medicine, and it is entitled Forensic Approach of Fatal Dog Attacks, a Case Report and a Literature Review. And so it's several pages long, talks about a specific case, and then on page 298, there are some significant passages that I would like to read, actually. So it says here, dogs have some very specific dental and maxillofacial features. They have 42 teeth, 20 in the upper jaw, 22 in the lower. Usually the mandibular dental arch is narrower and shorter than the maxilla, and that means upper, lower and upper. Maxilla is the upper. Maxilla, and the shape of the dental arches varies among the different breeds. There are natural gaps between the teeth that are attenuated or accentuated depending on the breed. The canine masseter pterygoid complex is short and strong, and its insertion on the mandible provides powerful mechanical advantage. So that's talking about the muscles, how powerful they are. And then goes on to measure the forces.
If you could find the location, if there's any in there with regard to pattern, is there any discussion about attributes and patterns in that study?
Yes, this next paragraph. The above features attribute to the characteristics of dog bites. The maxillary teeth distal to the mandibular teeth allow the so-called scissor bite in which the dog can lock onto his prey. The tremendous force of the bite, muscle complex can develop, allows the dog to twist and tear, and cause great damage. The injuries caused involve a combination of biting, crushing, tearing that results in characteristic patterns of punctures, lacerations, avulsions of the skin and soft tissue. Forensic pathologists noted the multiple torn wounds with adjacent puncture wounds, the so-called hole and tear combination. That's in this case. The puncture wound, a round hole, is made by the canine tooth of either the upper or lower jaw on one side that serves as an anchorage, while the other teeth cut into the flesh, causing stretching lacerations in the process of biting, shaking, and tearing. This should be considered pathognomonic for dog bites, especially when accompanied by tissue defects and claw marks, the latter being narrow, superficial, linear abrasions arranged parallel to one another, 4 or 5 in number, and usually found in the vicinity of the bite. This pattern allows differential diagnosis with bites of other animals, which are not accompanied by pulling and shaking, nor by the usage of prominent canine, and with stab wounds caused by sharp instruments.
Does that study support or not support in the literature a pattern recognition methodology?
That's sustained.
What do you conclude from the language you just read in that study with regard to methodology of discerning dog bite wounds?
That pattern recognition is very important.
Now what I would like, if I could approach Your Honor?
Okay?
Sure. If I could return this to Madam Court Reporter and please request Exhibit QQQ for identification. Thank you, Madam Court Reporter. May I hand it to the witness?
Yes.
Thank you, Your Honor. I've now handed you what is marked for identification as Exhibit QQQ. I would ask, please, that you, is that the Pollock study that you referenced in your direct and in your cross-examination?
Yes.
Could you please, as you did with the DeMunic study, can you please articulate the relevant, just the relevant sections with regard to your reliance upon that study?
Yes, so this is an article from the Institute of Forensic Medicine at the University of Vienna.
Is that a peer-reviewed study?
Yes.
Please continue.
Excuse me?
Please continue.
Okay. The title of the article is Fatal Dog Bite Injuries. And there's a summary. It says the dog's front teeth. So let me preface this. This was talking about a deceased child, and they describe the features. It says the dog's front teeth left marks of individual circular or scratch-like abrasions, as well as slit-like skin severances. Slit-like skin severances of the skin, arranged in curved lines. The pattern of the skin lesions largely corresponded to the anatomy of the dog's set of teeth. No tissue defects could be detected.
And is there any other section of that study that references pattern and pattern recognition methodology? Any other
Yes.
words, any other section? And if so, could you please read them?
Yes. So on page 491, there's a section called the Morphology of Dog Bite Injuries.
What does morphology mean?
It means the shape. And so it goes on to say the anatomy of a dog's teeth is the key to interpreting injury findings. The particularly long, cone-shaped, pointed canine teeth often create sharp-edged wound slits that can be mistaken for stab wounds. The bite mark on the skin is ideally a complete and congruent imprint of the front dental arch. Sometimes only the protruding canine teeth are imprinted. If the shorter incisors leave an impression, smaller skin lesions, parentheses, round pressure marks or streaky glide marks, can be found between the impact points of the canines. In practice, it is hardly expected that all 6 incisors will act uniformly.
I'm sorry, I didn't hear that sentence. Could you repeat that?
In practice, it is hardly expected that all 6 incisors of a jaw will act uniformly.
Is that sentence relevant at all to what you've referenced as an incomplete bite?
Yes.
How is it relevant?
Because if not all the teeth impact, then you get a partial bite. You know, you get irregular appearances. There's another sentence that's important here. A gap in the injury pattern can have several causes. Oblique biting, so what that means is not dead center on, but off to the side a little bit. Oblique biting. Curvature of the body surface, which we could have in this case around the arm, the edges of the arm.
Mr. Wu, could you please put Exhibit 1 back on the case? And Dr. Russell, would be helpful as you're discussing these items if you could determine whether or not what's discussed in that study is at all depicted in this exhibit.
Okay, so we discussed oblique biting, which is off at an angle. Curvature of the body surface. So here we have a body surface that's actually quite irregular. There's curvature down here. There's definitely curvature around the elbow. And so there's curvature around the bones. So curvature of the body surface can change the appearance of the wounds. Interposition of textiles, so that would be clothing.
Is there an example of interposition of textiles in this case?
I don't think so.
Well, was the decedent
Oh.
in this case wearing any, is textiles mean clothing?
Yes, and I thought
Was
you
the
meant in this
decedent-
article. But yes, there was textiles in this case. Mr. O'Keefe was wearing that hoodie sweatshirt.
Please
or
continue.
sweater, shirt. So interposition of textiles. And then it goes on to mention some other things which I don't think apply in this case, such as different tooth lengths, tooth loss, abnormal teeth.
And is there any other aspects of that study that are relevant to your analysis and methodology with regard to evaluating the wounds in Exhibit 1?
You know, a lot of this article is relevant, and I don't know if you want to keep, you
I
want
don't
me
want
to
to,
keep on reading.
keep reading it, but if there is a section, because then I'm going to have a few more questions once you're done identifying the most relevant sections of the article.
Yeah, this. And then there's one section that said,
Thank you.
yes, thank you. Then it does mention that in some victims, parallel scratch marks originating from clawed paws are found accompanying the injuries.
And is there any other section that you believe supports your evaluation of the wounds on Exhibit 1?
No, I think that's it.
All right, so, thank you, Your Honor. May I approach?
Yes.
Thank you, Dr. Russell. Madam Court Reporter. So do those studies, the Demunick and the Pollock that you just referenced, do they support the methodology of pattern recognition that you applied in evaluating Exhibit 1?
Absolutely.
And do they directly or indirectly support that methodology?
Directly.
And is that medical literature peer-reviewed support or not for your pattern recognition methodology?
So as to the form, Mr. Lessing.
Do those studies, each of them, those peer-reviewed studies, support your pattern recognition methodology that you applied with regard to Exhibit 1?
Yes.
Did those studies look solely at individual wounds, or did those studies' methodology look at the overall pattern to evaluate and discuss wounds from dogs?
Ask it differently.
How did those studies evaluate wounds with respect to individual wounds and overall wounds? How did the study evaluate those?
They described some individual wounds. There were numerous wounds. Described some individuals, but they looked at the overall pattern to make recommendations.
Was the pattern, overall pattern in those studies important or unimportant in the analyses and conclusions that those authors reached?
Important.
Now let's switch topics. Attorney Brennan asked you about various considerations you made with regard to differential diagnosis. Do you recall those?
Yes.
Let's just start with your differential diagnosis methodology. You describe whether or not you took into consideration additional information that was presented to you in determining whether your initial hypotheses was correct or not? Describe just generally that process and whether or not you took new information and retested your hypotheses. Describe that process that you undertook just generally.
So in general, when a physician is presented with a set of circumstances or wounds or symptoms or whatever, they come up with a possible diagnosis, but have to consider other diagnoses as well. That's what a good physician does. They consider what they think is the most likely, and then they go through a process of eliminating the or including and the other possibilities. Would you like me to give an example, like chest pain or
Well, I'd
abdominal
like to
pain?
give you an example of what you used here in this
Yeah,
case as
okay.
the application of that.
Well, okay, so I'm just describing the overall process, because if you came to a diagnosis and narrowed in on it and never considered any other information, sometimes your diagnosis is going to be wrong. And so you have to allow for other information. And so I did that in this case. I examined the circumstances, examined the wounds photographically, and came up with my impression, but I also considered other possibilities. What else could cause those scratches or those abrasions?
And did you honestly and scientifically consider those other possibilities as you continue to review the information, old and new information in this matter?
Yes.
And did that process allow you to avoid confirmation bias?
Yeah. Yes.
So in terms of that process, now let's go through some of the items that Attorney Brennan discussed with you. He asked you several questions, one of which, did you evaluate news clips and audio clips? You remember that questioning?
I remember a question about some news clip.
And did you recall your discussion with Attorney Brennan about acute grief reaction? You remember that discussion?
Yes.
Now, in terms of acute grief reaction, you talked about it, and do you recall discussing that sometimes people who have a traumatic event, that acute grief reaction occurs? You recall that discussion with Attorney Brennan?
Yes.
Now, do you recall also mentioning that sometimes these patients engage in self-blame?
Yes.
And my question, among others, is when they go to self-blame, from your experience as emergency room physician, seeing patients with this, as you discussed with Mr. Brennan, are there instances when patients blame themselves for something when they're not to blame?
Sustained.
Can you discuss what you meant by self-blame in acute grief reaction?
Sustained.
Your Honor, may we approach?
Okay.
May I have a moment, Your Honor?
Yes.
Thank you. Dr. Russell, do you recall questioning by Attorney Brennan with regard to some alleged clip with regard to a motor vehicle, the Lexus and the pedestrian in this case? Do you recall that discussion?
Yes.
And have you reviewed and Attorney Brennan asked you about the slide presentation that what Dr. Welcher did with regard to this supposed accident reconstruction? You remember those questions?
Yes.
Mr. Wilk, if you could please publish the slide from Dr. Welcher's presentation with the arm out in the glass in the back, not that one, the one in this case of the Lexus and Dr. Welcher dressed up as Mr. O'Keefe and with the clothing in the back, but with his that would be toward the back of that slide presentation, probably around 130-ish, 120. That's it, yes. And what slide number is that? 109. So, Dr. Russell, can you see what is depicted on that slide?
Yes.
Is that impact that is depicted on this slide, is that a clip or is that a direct impact to the arm?
I believe that that's a rather direct impact.
Okay, so this is a direct impact. And now, from your experience, and you were asked about this on cross-examination, a direct impact to the arm, assume, as was discussed, a motor vehicle, 6,000-pound Lexus going 24 miles an hour in reverse with a direct impact on the arm. From your experience as an emergency medicine physician, what type of injuries would you expect to this arm?
So I would expect at least significant bruising, at least. But I would also expect fracture, possible dislocation of portions of the arm.
What portions of the arm would you expect fractures and dislocations?
Well, from this image, if it impacted that section of the arm, and let me use my pointer, right here, a very good possibility that there would be a radius and ulnar fracture of the forearm or an elbow fracture.
Could you please stand up and with your Honor's permission, show where the radius and where the ulnar bones are of the arm? The lights on, please. Thank you. You can keep the lights on.
So the radius and ulnar are the two long bones in the forearm right underneath the skin. And then they join with the humerus bone here in the upper arm at the elbow. And those, of course, these bones are they're susceptible to fracture with a significant impact. And also the elbow would be susceptible to fracture.
How about the hand?
The hand could be injured. It depends on where the hand was in relation. And also, if there was a fall, there are other mechanisms that could contribute to a fracture from the actual fall onto the ground. So there could be a wrist fracture, digital fractures. It depends on the circumstances.
Thank you. And do you, you can be seated. Thank you very much, Dr. Russell. From a direct impact to the arm, as you said, is depicted here, what is the likelihood of there being any fracture to any bone?
Sustained in that form.
Do you have an opinion based upon a reasonable degree of medical certainty as to whether there would be any fracture to any bone?
I believe that there is a very high likelihood that there would either be a significant bruise or a laceration or a fracture of the bones.
Now let's go to, as I understand it, you have reviewed the autopsy report of Mr. O'Keefe?
Yes.
And you've reviewed the file, the medical records files, correct?
Yes.
Is there any indication at all of significant bruising to the right arm of Mr. O'Keefe?
No.
With regard to the lower extremities, from what is depicted here, meaning this impact, did you evaluate the autopsy and the medical records to see what evaluation was done of the lower extremities?
Yes, a very extensive evaluation of lower extremities was done.
What very extensive evaluation was done and by whom?
By Dr. Scortabello, and it was both an external and an internal examination of the lower extremities.
Let's start with the internal examination by Dr. Scortabello. Could you please describe what type of internal examination she performed?
Well, she opened up the legs.
Sustained.
May we approach her for lunch?
All right, jurors, I'm going to send you out for lunch, okay? We'll see you at 2 o'clock. Yes, come on up.
If he has PTSD, to deal with it, not go to a doctor at a cannabis clinic where they're going to, of course, prescribe you marijuana.
They're MDs licensed by the state of Texas. I mean, that's just
I don't know that.
Judge Fleischer is taking a firm stance on a complex DWI case involving medical marijuana, sparking a heated debate. The defendant, facing a DWI charge for marijuana, presented a controversial defense, a valid medical cannabis prescription. However, Judge Fleischer expressed serious concerns, stating, "I have a problem allowing someone who has a DWI because of marijuana, continuing to allow him to smoke marijuana." Judge demanded immediate verification of the prescription and a temporary cessation of use, questioning the necessity of marijuana over other medications and pushing for answers from the prescribing doctor. "I'd like to know why there's no other way to medicate," Judge challenged, highlighting the defendant's concerning history. 6 arrests since 2018, all linked to drugs or alcohol. Judge also expressed skepticism about the impartiality of cannabis clinics, insisting the defendant consult a legitimate psychiatrist. The case raises significant questions about the boundary between medical treatment and legal regulation in the context of medical cannabis use. Can the court accept the use of medical cannabis when it's involved in a criminal case? Stay tuned for more on this developing story.
So, Judge, they called the Texas number.
Saba actually called a line and has information for it. I don't know if it's going to be helpful to resolve things today, but I think it will be helpful to move things in the future, potentially. So.
Judge, so I spoke to, what's the name of the?
Texas Compassionate
Yeah,
Use
Texas
Program.
Compassionate Use Program. I spoke to them. They're gonna give me, they said confirmation within 1 to 3 business days regarding whether or not the defendant in fact does have a medical marijuana card.
I have a problem allowing someone who has a DWI because of marijuana, continuing to allow them to smoke marijuana.
Let's verify first that he does have a lawful prescription through the state of
I'm going to
Texas.
tell him no smoking for now until we're able to verify something.
Okay.
No, but he has a DWI for marijuana. We're
But
going
that'd be like you telling a diabetic can't have their insulin. It's a.
No,
Just because you disagree
no.
with it doesn't.
That's a
mean
life,
it's not.
diabetic medication. It's a life-saving information. This is not.
I mean, marijuana is too now. We don't know. I'm not a doctor. You're not a doctor. We're not researchers. But enough has happened with the legislature has approved this, and the prescription has been. If it's truly a valid prescription from the state of Texas, I think there's a problem with this, Judge.
I'm going to tell you, even if he has a valid prescription, I have a problem allowing someone to use marijuana when they're on bond for a DWI with
I
marijuana.
get that, but that's not Judge. That's not appropriate. I mean, what you're saying is if that is a true legal medication, you're saying that you just don't agree with that medication. If it's truly a legal prescription, that's what I'm getting at. And I'm not trying to pick this
Come
fight
up,
or
sir.
anything. I just
Come up.
But I want.
I want to know why there's no other way to medicate.
That's for a doctor to tell us. Is I don't know, Judge. I'm not qualified to
What
give that opinion.
I'd like to do is I'd like to talk to the doctor who prescribed it to figure out why there's no other reasonable way to medicate.
If the doctor will talk, I mean, let's wait to let's get the confirmation from the state of Texas that it is a true lawful prescription. I'm not trying to pick this fight with you if it's not. That's
Understand.
stupid on my part. But
Listen, I have thick skin and I'm not going to begrudge you for zealously advocating for your client, but at the same time, also have thick skin that I have a DWI. It's a marijuana DWI. And anytime I have a DWI with whatever substance that is, I have them stop using whatever substance that contributed to the DWI, whether it's alcohol whether it's pills, whether it's marijuana in this case, whether it's psilocybin, whether it's acid, meth.
What if it's Xanax or cyclobenzaprine or tramadol? We don't do that. You see what I'm getting at?
Xanax, yes. I mean, yes, but why not use Xanax instead of marijuana then?
Well, people rob convenience stores on Xanax.
No, 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 no. Now you're, don't, now you're getting apples and oranges. But no, but
And I don't know.
there has to be another way to.
Why don't we do this? And this is what I've done in Montgomery County, which you know they are way harder to deal with because when you practice. Why don't I do it this way is get a letter from the doctor that states what Montgomery County does is that based on their analysis and their treatment and whatever plan it is, that there's no other non-narcotic medication.
But I know that any doctor's gonna write that. I really want to know
That's their medical
why.
license on the line if they're lying. They're not gonna make that statement, just like I would as a lawyer.
But Dustin, I would like to know why there's no other way to medicate. Why can't they take Vraylar? I'm not a medical doctor, but there's so many other antidepressants out there. There's so many other medications to use.
Let's just wait. Well, first let's wait to see the state of Texas, the actual state of Texas is authorizing that as a prescription. Let's just do that first. And
I'm going
then,
to assume that that is the case.
Okay.
Even if that is the case, we still have the same thing. I'd like to know why there are no other ways to medicate other than marijuana.
right, but we don't stop somebody's medical treatment while we're waiting to get that resolved. That's all I'm asking is like, let's work, let me work on that and get it, but please do not order him not to use a prescription medication that he has.
But I don't know I don't know if it's prescription.
But if we get that, you say Pursuit does. So if he's lying and it's not a prescription, well, then that's a whole other issue for all of us, including his attorney. But today, the main thing I'm here today on is I need you to order him to have a portable device because he has no vehicle.
Do what?
I need to have the change to a portable device because he has no vehicle. He can't put an interlock on his car because he doesn't have one. In fact, it was a wreck, so he has no car.
So where's the car?
You tell me that, I have no idea.
It is, it's actually, they just got out the lot and it's at a repair shop.
Once it
So
is
he's
repaired,
gonna
he
get a
will
car
put it
any
on.
minute.
Right, he'll put it in as soon as it's repaired, but he doesn't have one right now.
Get the car back.
They said it could take anywhere from 5 to 6 weeks because the axle broke off the tire wheel.
An NCIC on him. I'd like to see what full kind of criminal history that he has, please.
And I can tell you, Judge, I've represented him for a long time. He's got the one car DWI here. He has a PTI program for heroin use that he completed, and he's off heroin use. And part of that was the PTSD causing him to use drugs, and that's part of this passionate use now.
Another DWI?
It's a second. That's why he has that's why you ordered him in law, because it's a DWI second.
How long ago was the other DWI? And where was it?
He was here in Harris County, Judge.
It was about like 6, 7 years ago, like 21, 22.
And then it's got the dismissed PCS that was that he did the PTI program through Rick Court.
Last name again?
It's Caleb Jones, Judge. It's all your history's here in Harris County, correct?
Yes.
Okay, that's what I thought.
He's had 4 total arrests, Judge, 2 DWIs.
That's this one, is one of those.
Yes, and possession of a controlled substance and an unlawful carrying of a weapon.
What
The
was
first
the,
DWI is 2018, Judge.
Yes.
And the PCS was a dismissal. I don't remember if the UCW was a dismissal or not. I don't remember. I represented them on it, but I don't recall.
when was the PCS? What's the cost number, please? Because for some reason I don't have it here.
I can give it to you, Judge. The cause number for this is 2532601. So the carrying of a handgun was in 2020 in a motor vehicle. That was in 2020. It was dismissed, Judge. The possession of a controlled
It's a
substance.
6th case.
Well, I don't have access to this juvenile stuff, but I see 4.
No, I'm not looking at
Criminal
juvenile.
history.
I'm not
I don't
looking at
think you have
juvenile. He has a UCW that was dismissed.
Okay.
Unsatisfactorily terminated probation
On DWI,
from 2020. A year later picks up a gun case. A year later picks
which
up
is dismissed.
a year later
Dismissed.
another
session was dismissed. This is this one. But there was this one on the possession case from 2020. That was a conviction, 6-month state jail, deferred adjudication. And then that, and DWI from 2018 was unsatisfactory termination.
I didn't know about that. I didn't see the other PCS judge. I'm sorry. I was gonna get there.
He's never successfully completed a probation.
Completed a PTI program. Didn't he? Am I wrong?
No, it says unsatisfactory.
No, the PCS was a PTI program, wasn't it?
No, I didn't.
You didn't complete it?
No,
Okay.
That one was.
That's why I was sent to state
I'm
jail.
sorry. I apologize if I misspoke. So that was when he had an opiate problem.
Well, I had finished it and
There
then the
was
second I
another-
got out of one.
Okay.
Yeah.
I drug test you now, what's gonna show up?
The marijuana, sir.
What else?
Well, do you have prescription? Your prescription?
I do have prescriptions. I take a Valium like only when like I have a seizure because I have epilepsy, sir. But other than that, though, everything else is non-narcotic. I take a Lamictal. Oh yes, I do take Subzol. That's to help me out keep me off the pain medications and stuff like that. Suboxone.
What else?
And
Do you have a Xanax prescription or no?
no, it's Valium.
Valium, sorry, my mistake.
But it's a nasal spray though, so it's only like when it's necessary. I'm actually like in a seizure.
I'd like to send him for a drug test now. I want to know everything that's in his system.
That's all you have in your system is what? The marijuana?
The marijuana, the Subzol, and
Suboxone?
Yeah.
Okay.
I don't know, Dustin. I don't know. I don't know if we're just contributing to the behavior. You know, I mean, I don't understand. What I don't understand are why there's no other ways we can medicate.
Judge,
My
my concern at this point is that I don't know what the test says of what he was or was not on at the scene, because my understanding is the DWI took place, what, on the 8th or something? When was it?
It was a week ago. We were hearing court on Friday.
Right, so it takes about 30 days to figure out what's actually in his system or not in his system. So I'm struggling with that.
Is there a breath test? Is there a blood test? What is it?
It's a voluntary blood, Judge.
And we don't have the labs back, Judge.
It's a 4 or 6 HGN, 0 walking, a 0 1 leg stand, 4 walking turn. He had medical marijuana on him, like the prescription.
Living.
I'm sorry.
Do for a living.
Right now, I'm waiting on disability, but I do like entrepreneur work where I like stock invest and stuff like that, just to make some pocket change. I'm sorry.
How do you get money?
Right now, I'm in between jobs, sir.
His parents hired me, Judge.
Dustin's not cheap.
Oh, no, my parents helped me with that, sir, on a payment plan. It's very hard to find work when you're have lupus and epilepsy and stuff like that.
Baloney. It's hard to find work when you get felony convictions. And what you do in the last 5 years, you picked up one case every single year. And you want me to continue to allow you to smoke weed. I have a problem with that. And I really do, Mr. Jones, because historically speaking, since 2020, since 2018, you are now on your 6th case. And I get it that some of them been dismissed, but nevertheless, it's 6 cases. And all of them have to do with either drugs or alcohol. So for me to allow you to continue to use, it would be enabling you, telling you that it's okay when it's not. In life, this is addiction is a lifelong problem that you're going to be dealing with. And at some point, you're going to have to get off of everything. You can't continue this forever, because the problem is that at some point, whether you're going to get this, whether you're going to get that, whether you're going to the dealer's house to do this, or wherever you're getting your stuff from, peer pressure's a bitch. And it scares me to think when you're at a really vulnerable moment in your life, when you run into the wrong person, you may end up spiraling out of control, where once you are able to deal with this, because it's mind over matter, when you have a strong mind and when you have a strong heart, you can do anything in life. And if anybody tells you otherwise, it's baloney. Because with a strong mind and a strong heart, you can achieve anything in life. And what I don't understand is how you cannot find another way to self-medicate. That's what I don't understand. And that's why I would like to talk to the doctor who's prescribing this to see why is there no alternate way to medicate? I mean, he's already on Valium. Did you say he's on Xanax as well?
I used to when he has a seizure, Judge. I was wrong on the Xanax. It's Valium, not Xanax. I was when he has a seizure. But he's on.
One hand, it's
He used to be,
6 and doesn't, 1/2 and the other.
Judge, all I know is a doctor's prescribing it. He doesn't get it from the dealer. He gets it to the state of Texas through their pharmacy. So I don't know what else to present to you. 'Cause that's all I can present to you. Yeah. I guess let's try to do a rush on the blood and do a quick trial setting. And get that
The
report.
other thing I'm gonna do, Dustin, is this, is that if it's an absolute must, I don't want him out in the middle of the night. I'm giving him a curfew because I don't trust him and I don't want him out in the middle of the night. Nothing good happens at 1 or 2 in the morning, and I don't want you out in the middle of the night. And I'm going to give you a curfew, because if you're gonna continue to smoke, the last thing I want is you out in the middle of the night being up to no good.
And I think you'd rather do that, Judge.
I honestly have no issue with that at all.
And I'm going to put a monitor on you so I know where you are and I don't want you out. I'm going to give you a curfew, 10 PM to 6 AM, but you're not out in the middle of the night. And then I want you back here in 3 days and bring me what you got. I'm telling you that I'm hard pressed and I want to know why there's no other alternate method of treatment, that it has to be marijuana.
So you're not allowed to use the marijuana yet. So let's not put him on a curfew yet.
No, I'm not gonna, if I'm gonna give him a curfew, I'm gonna,
Okay, that's fine.
But I'm back here in 3 days and I want to know why. And I want to know why there's no other reasonable way to medicate and it has to be marijuana. And the only reason is because this is a DWI with marijuana.
When are you seeing your doctor again?
I'm actually supposed to speak to the cannabis clinic tomorrow.
No, I don't care about the cannabis clinic.
That's the doctor.
That's the doctor. That's
the doctor that prescribes the Judge.
I see. So it's the fox guarding the hen house.
I have no idea. I mean, that's a little bit, well, no, only those doctors who are licensed by Texas can prescribe it. So yes, it is the cannabis clinic because that is the only doctor who can prescribe it. They have to register with Texas.
Going to the cannabis clinic. Where is it?
You have to get it. Well, that's
Austin, actually.
They're in Austin.
They're
There's
out
actually-
of based out of Austin.
There's now one over on Richmond Avenue that just opened because I
Yeah,
was.
they have satellites here in Houston, but they're based out of Austin.
Judge, if we are getting a reset on this, I just ask that it be.
It's not even a reset. It's off topic because I'm trying to get the driving issues.
Yes. Okay.
Yeah,
Just by 1 to
253-2601.
They said 1 to 3 business days. So I should have it, their response by Tuesday. So let's say it's for Wednesday, if you want to come back in at that point.
Can we come in on Wednesday, Judge? That's when she'll have to.
Sure.
Back to the doctor.
Sure, but
I'm sorry, from the state of Texas.
According to-
so he gets the monitor. I'd like to send him for a drug test now. I want to know what everything is in the system. If there's something more than just value, I'm going to have a real big problem with it, Dustin. If I see that there's opiates in there or something else that's not supposed to be in there, I'm telling you now, I'm going to have a real
Suboxone,
problem.
whatever that shows as. I don't know what Suboxone shows as. But that will be in
It
there.
shows up as buprenorphine.
Okay, then yes, that will
So
be.
if it's Suboxone, it'll show up as buprenorphine. But if it shows up as benzodiazepine,
And you haven't used any opiate, you haven't used any Valium or anything recently?
I went to the ER and they gave me some medication.
What day?
I don't have the paperwork. It was
Last week, 3 weeks ago?
Yeah, it was about like a week and a half ago.
That's,
Something like that.
that'll be,
Oh, but that's it though. That's it.
okay, but we need to know what that is.
Yeah, but
we'll see. I'm sending him for a test now, but I'm going to tell you now. No dope while you're on bond in this court.
Sure.
Unless otherwise given. If I find that you're using any kind of opiates whatsoever, I'm going to keep you. And I don't care if they're hooting, hollering, crying, no opiates, no alcohol. Do you understand? You get a monitor for both today.
Sure.
So I'm gonna put a scram on one, a thing, and I'll pay for everything.
Because he has no alcohol issues, and I mean, he hasn't used alcohol in years. No, I mean, it's not even alcohol DWI, there's zero alcohol at all on this DWI. That's, I know you're saying, that I'm arguing for you, because I think having the scram and I think the scram is a little excessive, Judge. It truly is.
See, one in lieu of the other I was gonna do. I'm not gonna do both, that's silly. Of course not, I'm not gonna do both.
Okay, so just so we have two ankle monitors on one scram and one GPS, then he doesn't have to worry about the blower, the portable.
You want the blow?
Well, I'd rather have a portable than it's just, that's a lot to be wearing and stuff. I mean, I don't know, do you okay with
So,
going every 8 hours?
I'm
GPS with a curfew, and then he gets a portable today, please.
Yes.
And then the curfew, and then we send it for the test now, and then we'll see him on Wednesday.
We have the curfew of 10 PM to 6 AM.
And then waive all the fees.
Thank you, Judge. And do they have portables through I know I'm arguing
know.
for that. Do they do portables through probation? Is he able to get a device that probation pays for it or raise it?
I have no idea about the petition.
Okay, I'm sorry, or through pretrial, whoever.
Is he able to get a approval through?
That's what I'm asking.
Retrial?
Yeah.
Yes.
Okay, perfect. That's.
Listen, I'm gonna tell you now, though, if he's using opiates, and I'm gonna tell you now, if I find that you're using opiates, you and I, our life together here is going to be very, very difficult. It stops now. Do you understand? You need to do whatever you can to stop using, because if you don't, I am now affording you the opportunity to stop using everything now. If you don't, we're going to do it my way, and I promise you, you're.
sorry, I didn't hear that last part.
He didn't hear your last part, Judge. I apologize.
I'm giving you the opportunity to stop using dope now. If you are unable to, then we're going to do it my way. And I promise you, you're not going to like the way that I do it. It's going to happen. It's not if, it is when, and it's now. Do you understand?
Absolutely.
Because I'm done playing. And the last thing I want, believe it or not, Mr. Jones, I want what's best for you, okay? And sometimes we have to save people from themselves. But so far, whatever you've been doing, it's not working because in the last 6 years, you've got 6 cases. So whatever you're doing, it's not working. And you need to do something to change your life, because I'm telling you, it's going to be a lifelong battle with you. And you have to come to terms with it, that this is mind over matter. You need to find something to do. You need to find something to occupy your time, because when you have too much time, you become self-destructive, because that's the type of personality you have. And I'm telling you, because I have the same personality as well. I'm a very self-destructive person, but I'm always occupying my time, whether it's playing Fortnite with my son, whether it's running in the day, whether it's, shaving my dog's pup gut, whatever it is. I'm always finding time to occupy myself, and that's what you need to do to get over this lifelong battle, because if not, it's going to take you by the boo-boo, and it's not going to end up well like it has been so far. All right, see you soon.
Judge, so just to confirm, we're removing the condition to get the IID. Jones, right this way.
To do the what?
The ignition interlock.
No, the ignition interlock stays, because that way DPS needs to know.
All the previous conditions, just adding.
Correct.
Testing today and getting those devices.
The next day.
We were, I'm on, Kaylee Jones, sorry, I was kind of blank there. So they contacted the compassionate use program last week. They told her 2 to 3 business days, and they sent her an email saying that they wouldn't give her the information without my client sending a request authorization form. So she just told me that, she forwarded it to me. I'm gonna do that today and get that handled. And I don't know how.
Friday afternoon, Judge, from them. So after.
But I'm telling you now, I'm gonna have a problem with it. I don't think it's the right thing to do. Not when you're on, there has to be other ways to medicate other than with marijuana.
I honestly can't tell you that. I honestly don't.
Well, then I want him to see a legitimate, psychiatrist, doctor, if he needs to if he has PTSD, to deal with it, not go to a doctor at a cannabis clinic where they're going to, of course, prescribe you marijuana.
They're MDs licensed by the state of Texas. That's just like.
I don't know that. And then, I got to imagine that if he goes to a regular psychiatrist, just a regular psychiatrist off the street? Are they going to prescribe marijuana or are they going to
They're not allowed
prescribe something else?
They really can't. They have to be licensed with the compassionate use program through Texas. So no, you're right. Your therapist cannot prescribe it because they're not licensed to do it.
Right.
Like this cannabis doctor is licensed to do it.
I don't feel that it's right when someone has a DWI with marijuana to let them continue to smoke marijuana.
I understand.
So,
I mean, I understand your position, Judge. And what do you want me to do at this point? Like right now, what is your wish?
if he truly has PTSD,
Yes.
then I think that he really needs to see a doctor, a licensed psychiatrist, not just the people at the cannabis clinics.
Okay, so you want him to have another doctor that he's treating?
Well, no, I don't, I just, there has to be another way to.
Position that's gonna put me in a bind for telling somebody they can't go to their doctor, like.
No. And look,
I'm not trying
you
to-
guys do, you guys need to do whatever you're gonna do, right? But
None of us want to deal with. I don't want to deal with it.
And I'm gonna tell you, it's a new thing for all the judges here now with all the marijuana cards now, trying to deal with how someone medicates, especially when someone has an opiate problem and they're continuing to use. And they want me to okay to continue to smoke marijuana.
I will say,
I don't.
Judge Giddey has approved it for a client of mine, and Judge Ward.
I don't care about other judges. I don't care.
But what's gonna happen is if you convince them that they're prescribed by their doctor, it's gonna be a huge blow up that none of us want to deal with. Like, I don't want this on the news. I don't want to be the lawyer standing from the camera.
I don't care.
Nobody
I
wants
don't-
to. This is medical. This is not legal. It's not a legal issue. It's a medical issue. But when you make it a legal issue, then that's where it gets to be a little sticky between this, because if the state of Texas says it's okay, I don't see where don't take this the wrong way. I don't see that you have the legal authority to tell Texas they can't do that. And that's what we're getting into, because you're saying that doctor.
If someone has a DWI, a marijuana DWI, right? And they want to continue to smoke marijuana, I have a problem with that.
What if they have a Xanax DWI and they want to continue using their Xanax that their psychiatrist prescribed? What's the difference?
And I don't know, I have not come across that issue, so I don't know what I'm gonna do. But
Medication.
I have a problem with it, Dustin.
That's not.
So
Morley doesn't have a problem with it. You're telling somebody, a licensed physician prescribing something, they can't use it because you have a problem with it. That's the issue that we're seeing. So, I mean, I respect the court's, whatever the court, orders, we'll respect that, but I just didn't know what steps you want me to take. Like,
I don't know, let me think about it, because I'm gonna talk with the other judges as well to see what, because I'd like to get a second opinion as to what other judges think about it as well.
Okay, I don't know fights, you know that. Like, I'll zealously advocate, but I'm not trying to start something that doesn't need to be started.
Dustin, I'm never gonna begrudge a lawyer for zealously advocating, and I respect you for doing it. Really, I'm never gonna fault you, but I really have a problem with someone who has a DWI and they're continuing to use the same substance that they got the DWI with. In every respect, when I see that come here, I try to get them to stop taking whatever they're taking.
Yeah. And I will advise him he should try to take those steps. I mean, I got a problem with that.
I have to imagine, had he gone to a normal, any other psychiatrist other than one at the Cannabis Cup, they 9 times out of 10 would have prescribed alprazolam, something else to deal with the PTSD. And I mean, what is it here? He shoots himself in the finger. Isn't that the PTSD?
Yeah. I mean, everybody's made different.
I get it. But regardless, I think that, have you seen anyone else?
So I guess can we reset for a week? That way I'll get the documentation. I'll
How
get
long
you
is
some
it gonna-
information.
Judge, I'm not sure. They emailed me
I don't
on
want
Friday.
that long, Dustin, because I don't want him to continue to smoke weed.
Well, he is on your curfew and he's on the monitor. So I mean, we're at least keeping him from being outside during the hours that you're concerned about.
How long do you think?
Judge, I really don't know how long it would take them to process it. Say hypothetically, if they told me 2 to 3 business days and then we send it to the class today, I don't imagine that they would take longer than 2 to 3 business days, but he's going through it with a HIPAA. So
they're gonna have to, what this is saying is he has to email them with his information, then they're gonna send him a form that he's gotta fill out allowing that information to be given. So
Say it
as soon as they,
takes 2 to 3 business days for them to respond to him, and then with the
Okay, so
form.
let's do this. I'll set it off for a week.
Yeah.
I'm sending him for a drug test now. Come up, Mr. Jones.
I think that's great, Judge.
I mean, he had no problem doing his weekly testing.
Doesn't, if he's using any kind of opiates, I'm gonna, if you're using any opiates, anything that you're not supposed to, it's not going to go well between us. Do you understand?
Absolutely, yes, sir.
How come you have not seen any other licensed psychiatrist other than the cannabis people?
I actually have. I was prescribed alprazolam for 6 years, but it actually caused me to have like seizures if I like missed it like a couple hours late and stuff like that.
You're not supposed to stop taking it.
I'm not saying like not I'm saying like if I slept in, like I could actually wake up at like 8 o'clock in the morning and have seizures because it's delirium tremors is what they call it.
Side effects of when you take hardcore, powerful narcotics like these, you can't just stop taking it. You can't just, when you stop, they wean you off. And when you don't take it as regularly prescribed, there are serious side effects. One of those being, convulsions, all types of side effects, including seizing, right? So it's not because you're taking the Xanax, it's because you didn't take it when you're supposed to. So don't blame the Xanax for causing you to seize. It's the fact that you didn't take it that caused you to seize. Why not? Why stop? So you're not taking the alprazolam anymore?
No, I still take the Valium, but only for emergencies for seizures. It's not even for the PTSD anymore because I didn't.
Emergency seizures?
No, emergency seizures.
He has epilepsy, Judge.
Yeah, I have epilepsy, sir. That's another reason why they were giving me the Xanax too. But like, but they were saying that it was actually making it worse. They called them delirium tremors, similar to like withdrawal from alcohol. The benzos do the same.
Tremendous.
Yes, sir.
Sure.
So that yes, sir. They're saying that it was helping, but if I
the other thing is I can't imagine that if you have one doctor prescribing all this other stuff, that doctor is going to continue to let you take all this, knowing full well that you're also using marijuana from another doctor, because they're contradictory and you can't do that.
Sir, I wasn't taking them at the same time.
Okay.
Yes, sir. I had stopped the Xanax actually when I was when I went to jail for that state jail time, and whenever I got out, I was on like different medications in here and stuff like that. I just didn't want to go back on the same narcotic while I'm trying to stay sober, sir. So I mean, I know marijuana is not much better, but I just felt like it was better off taking something that wasn't physically addicting versus with the doctor's opinions and stuff.
It can be as well. I mean, look, I'm sending you for a drug test now.
Yes, sir.
We need a complete list of everything that you're legally prescribed to take, because I want to know what you're allowed to take, and that's it.
Yes, sir.
Because I also need to know what's going to show up in the blood test and what's not supposed to show up in there.
Yes, sir.
But don't use anything that you're not prescribed to take.
Yes, sir.
And for sure, you best not get into a car.
Yes, sir.
I will absolutely lose it if you get into a car. Do you understand, Mr. Jones?
Absolutely.
I
Yes,
don't know how much more plain and clear that I can make this to you. Don't get into a car.
Thank you, Judge.
Hold on. I need to make sure that if he signed an affidavit that he's not going to drive. He does. Okay.
understand that?
I believe so.
We'll set you off for a week, and then before he leaves today, I'd like a complete list of what he's got prescriptions for to take as far as any kind of narcotics, and so we can see it. All right.
Could you provide that?
I want to know.
If not, you do that too.
No,
Give it.
I'm sending you for a drug test now.
Yes, sir.
Depending on what that shows, I want to look. Okay. All right.
Thank you, Judge.
Okay, guys.
Right this way.
Herman.
Several months later.
One issue, as far as the GPS monitor and all that, they gave him a new device just now. They said it was a charging issue. They plugged it in, it would charge for 10 minutes, stop charging. He has a brand new one they just put on this morning. Now, the drug test issue.
Violation that he's out at 3 a.m.
Well, no, it's not that he's out, is that's when it reconnected. So but they gave him a brand new device. So and they're saying there was an issue where they changed the device out. and there's not a tamper on it. It's just, it said it was not receiving. It didn't say it was that he was out and about. It said it wasn't receiving, and it would, they started receiving again. That's at least the report that I saw. It's not like they were tracking him other places. But as far as resolution of the case, I did talk to him and he is interested in participating in DWI court. And I know because we talked about that last week, and I had visited with him on that this morning.
Says here on 3/11/24, GPS device generated a failed to enter alert at 10:15 p.m. At 11:46 through 3:02, GPS device was in no GPS, no cell status and was unable to be monitored during the time frame. Client arrived home at 3:01 a.m. on 3/12.
So that's not when it arrived home. That's when it started charging again. Because it's not a geolocate. I mean, as far as I'm understanding, it's the GPS shows where he is,
I'm
not.
gonna be honest, Your Honor, that would be a question for pre-trial.
Oh, no, I'm sorry, it's pointed to the client, not to you.
Okay, I was like,
Saying he's out and that he's out in the middle of the night.
I don't think they're saying that. What they're saying is that it's received a no signal.
Client arrived home at 3:01 a.m. on 3/12.
Where was he before that?
Huh?
They don't know where he was before that. He was at home. He just wasn't charging.
You have.
That's the way I'm reading it.
Do you have? Do you have the idea of where he is?
I don't see any notes from the case manager, and then, at 10:05, I see on the report, it's showing that he's not at his home location. So I think that would be the fail to enter. And then there was the portable violations as well that were added. But again, from what we discussed earlier, I don't, necessarily have to go forward.
Portable the violation in what respect?
They sent an email yesterday from the supervisor that was here earlier, stating that there were additional.
Who's, did Anthony send that?
No, it would be from Cody Pittman.
Okay, I see.
Or this specific one is from Luis Galvan.
So I also have here, the client was also instructed to obtain a portable alcohol testing device, comply with all testing protocols, refrain from alcohol consumption, and comply with all routine equipment service. The defendant failed to provide breath samples, scheduled times, resulting in 13 skips from 2/7/25 to 3/17/25. So he's still skipping tests. Come up, Mr. Jones. I just don't get it. I truly don't. It's over and over and over. You are still skipping tests. And I don't know what it is and what I need to do to get you to comply with bond conditions. You're still skipping tests. I mean, I have no other choice. I now have to revoke your bond again.
Well, let's do a plea then.
Huh?
Let's plea it.
I agree with, and I'm okay, but I'm gonna tell you now that I want to have him TRAS'd immediately to see how we go forward.
Well, Judge.
You know,
Okay.
just. All I want you to do is not kill anyone, man. That's all I want, you know, really, I'm not asking for much. You have, since day one in our court, have repeatedly refused to comply with bond conditions over and over and over. And I'm not doing a plea to where he can just get out and just do, and
So,
you scare me.
so how do we resolve, Judge?
Huh?
So how do we resolve it?
So, yeah, I agree with you. I think that the correct thing would to do would be probation.
Okay.
But I would like to have him TRAS'd while he's in there. And I have a feeling I know what the TRAS is gonna say, and that's what I would like to do.
Okay. I would request you to set a bond.
Of course.
It's just costing him money, Judge. Already it's costing his family money.
So it's okay to just skip tests?
No, it's not. It's a test, but I'm saying is.
Skip, I might just be asleep, but I'm not trying to skip him wrong, I swear to
Stop,
God.
just stop talking. Yeah, you don't,
Sure.
just stop.
Okay, he goes, and it's literally, the minute he gets out, we have bond violations over and over and over. Now, what are we now, day what?
If the court wanted to be made aware of the presumptive results,
What did he test positive for?
THC, Suboxone, Oxy, and benzodiazepines.
He tested positive for Oxycontin?
Yes, Judge, presumptively positive, it's being sent to the lab for further testing.
What I had envisioned, what I think is probably do like a 2-year probation. I want to do like maybe 10 days as a condition, do an immediate TRAS. We'll get it done today, tomorrow, and we'll see what the TRAS says. And I'm going to go with what the TRAS says. If the TRAS says, and I promise you, Dustin, I will do what if the TRAS says that IOP, SOP is the proper course, then I'll do it.
Okay.
You know, but if they say residential, I think that I want to follow what the TRAS says because I think that that's the proper one.
I don't think you can take it. I just don't think you'll take it if it's residential.
Then I have a jury waiting right now.
You said the same thing. I mean, let's just see what it says. Let's try to get a quick TRS done.
For sure.
How quickly? do
So do you want to do the probation?
Yeah, he wants to do probation. Judge.
Okay, let's do it. Okay, Blaze, you let me know.
On.
Just probation.
Okay, yeah, I mean, we had offered the probation first, so, yeah, it's TRS.
So,
Okay.
So probation,
2-year.
TRS conditions.
2-year.
Okay.
I want to do 10 days as a condition. That way I can get the TRAS done now immediately while he's in. And then I'm going to follow whatever the TRAS says. Are you Dad?
Yes.
How are you?
Fine.
Thank you so much for coming.
Can I say something?
First, go with Dustin first, because I don't want you to say something that really, just,
No.
please. Yeah, you guys can talk and then later on, if it's, then, yeah.
Thank you, Judge.
Thanks, Dustin.
I may, I will the record, or does it matter? May?
Yeah.
Okay. Basically, Judge, our argument in the writ is that even if there's a detainer, he shouldn't be held in custody over 48 hours. We cite some case law.
He's on bond.
Bond. Mhm.
So I don't know what I can do to release him. And so when I was going to call the court manager's office, figure out why is he still being held? Because he's on bond. Why has immigration why have they not picked them up? And because I'm confused, I'm as much as confused as you.
Who's talking about?
What's the name again?
Martinez?
Martinez.
Because a bench warrant was requested. So Billy called about this one because she was tuning in. And she says that he's here because we bench warrant him here. And that if y'all want him to go back, then we have to do a bench warrant return.
But my question is, and because that's
We
why.
bench warrant people here because people ask him to be bench warrant. We don't do it on our own, right? So someone has to ask us. So someone must have asked for the bench warrant.
I believe it's prior attorney because we're doing this pro bono because we were helping him with the immigration case, filed the bench warrant. But as
So
far
we
as,
can do a return.
yes, Judge, but as far as I know, like the court stated, he paid the bond, so there's no reason for him to be detained. I have no problem, it's his return. That's fine too. But it's something that it seems to me that lately it's happening more than it should, and that's why we filed that writ.
Lawyers ask us to do with when these things happen. So if someone wants a bond revoked so that they don't go to immigration, we do it. If someone wants to have a bond so they can go to immigration, we do it. I always do what defense lawyers ask with regard to this. So
I'm unaware of that.
so someone asked them to be brought here. My feeling is so that they could take care of the case before he gets deported. That's what we normally do. So
I believe that that was done before we were helping him with his immigration
So-
case.
So what we'll do now is we can send him back when he gets back to immigration.
Oh,
That way,
perfect.
guys, you can make the
He already
bond.
has a bond, yeah.
Yeah, and I won't revoke it here. The only thing I'm gonna ask you to do is that when you do make the bond over there, bring him here so we can do conditions.
Yes, sir.
And then we'll just keep it open until you guys are ready. So just let her know to do the return and then, I don't know how long it'll take to get it like back, but,
That's why we filed the writ, Judge.
Hey Vic, when we do the return to go back there, how long does it take to get him back?
They're here pretty often, so I mean, I'm sure in a week he'll be back.
Yeah, and he should be detained for more than 48 hours because usually if not, that's why they're
Yes,
released.
but unless there's other circumstances, and when there's an immigration detainer, it's not us that's technically holding him, it's the immigration.
That's why we are in the motion, Judge. It's just, if the court could take a look whenever it has a chance, it would be
Sure.
good.
Yeah, but we'll do the return now so that we can just get him back in.
Whatever is fast, that's fine because
This is the fastest way,
they will.
Do you want me?
right?
Yes, to send them back, yes.
We can do that. Do you want me to put that application for writ of habeas corpus in queue, the one that he's talking about?
But I don't know, like if I grant it, I mean, it's just.
Can I ask just a favor,
Get him
Judge? If the court just, I mean, I think whatever is faster, I'm fine with that because we already got a bond for him there. But if
I
the court
think
could
what
take,
she's saying is probably the fastest.
but if the court could also, whenever have a chance,
Take a
take a
look
look
at
at my motion, okay?
Okay.
And maybe it's
Let her know and then we'll get it done for you now today.
Thank you, sir. Thank you.
All right, so what we're gonna do, Judge, is he's not gonna bond out. We're gonna reset it for she said she could get it to TRS in a couple days. I got him, he wants to see what the TRS is gonna say if he recommends DWI court, because that's kind of what he wants to do. Pretty much he's, I think he'd be more successful in DWI court. So let's get the TRS done.
In sober court,
It's a-
he just wants to be out so he doesn't have to be in custody, but the
Oh, no,
problem
this
is,
is gonna be, this is gonna be in your court.
it won't be in my court.
I understand that.
So
He's TRS that done, but he's not bonding out. Dad's not bonding him out. I told him he needs to sit and have TRS done, and they can get it done. So I'm gonna reset us. What, 5 days, Tuesday, and we'll have TRS by then. He's not gonna bond out because that's the we're not bonding out.
You want to talk?
Yeah, I don't want him on. I suggest I don't want.
I get it. I
You know
understand.
why.
I understand. I understand.
So, we'll do five reset for Tuesday next week, then they have TRS done by then.
Okay. All right.
Hey, Judge.
Got it.
And I'll get the.
So we're not doing a plea today, but hold on. Dustin, come on up. I want you to know that if it says residential treatment and he's no, I mean, I'm setting this case for trial, right? And I'm not gonna,
Are all full straight probation?
I understand.
Okay, cool. I heard for.
No, he was asking.
No.
It's not legally
my
possible.
concern is that what I feel is gonna happen is when he does a TRAS, they're gonna say residential, and he's gonna say, I don't want to do residential, I want to be out. When we know, based on here, it just doesn't work when he's out. He does what he wants to do.
If he
To
doesn't,
hell with the conditions.
if he doesn't want what the TRS recommends, then he'll take a jail sentence, and that's just what it is.
I'm not gonna take that. I'm not taking it. I'll send for trial. I'm not taking, no, because this,
He'll plead to a jury and do jury punishment, and he'll get a jail sentence. Like,
you can do what you want,
he's not
but
probation eligible for a jury. You can't force that probation. Let's say the TRS.
no, I think I can. I mean, I think I can. I mean, I'll look the code, but
If I do jury punishment, you can't. Like, it's, you see what I'm saying? Is like, I do jury
I mean,
punishment,
sure.
you can't.
Sure.
But I'm not trying to. Let's just get the TRS and see if we can get it to help if you want, yeah.
Dustin,
I know what, dude, we're on the same.
giving
I know you.
him a jail sentence of 20 days, 30 days, 60 days solves nothing. It literally throws him out into the wolves, and he's just gonna pick up a felony DWI within the next 30 days, 60
Let's see
days.
what the TRS says and see what we can do.
I'm trying to help this kid, man.
I know you are.
And just a straight jail sentence it's within a year, he'll have a felony DWI.
I understand. And you know I understand. You know where I'm going.
All right, so let's see what the TRS says and well, yeah, it's pointless an argument. I agree. Let's just see what the TRS says.
Thank you.